Chapter 1. Personal Jurisdiction and Related Matters. Key Exam Issues. Most civil procedure courses include consideration of where a suit may be brought. In a country the size of the United States, that can prove very important. Those issues raise questions of personal jurisdiction, i.e., a court's authority over the parties in the lawsuit, and venue, i.e., the geographic location where the case is heard. Note that a different jurisdictional question, whether a suit may be brought in federal court, is covered in Chapter Roman 2. Examination questions about whether a suit may proceed in the location selected by the plaintiff are very frequent. When you face such a question, ask yourself the following questions. 1. Is there a statute or rule that gives the court a basis for the exercise of jurisdiction? There must be some enabling legislation that authorizes the court to exercise jurisdiction. The traditional method for gaining jurisdiction is service within the state, but all states have adopted statutory authorizations for exercise of jurisdiction, even if there is no such in-state service, called long-arm statutes. Under these statutes, jurisdiction often depends on whether the defendant has done something in relation to the state or one of its residents. As a result, you frequently must analyze the specific wording of the statute or rule involved to determine whether the allegations of the suit satisfy its provisions. Moreover, some long-arm statutes have been interpreted to extend as far as is permitted under the Constitution, even though their express terms do not say so. In federal court, the same statutory jurisdictional provisions apply as in state court, except in a few special circumstances. 2. Is this exercise of jurisdiction constitutional? The Due Process Clause of the 14th Amendment limits a state court's power to compel a defendant to respond to a suit. Your analysis may require you to look to one or more of a number of grounds for satisfying this constitutional requirement. A. Does the defendant have minimum contacts with the state where the court is located, the forum, that are sufficient to support the exercise of jurisdiction? This analysis is often called specific jurisdiction because it depends on the specific claim being asserted. You should consider whether the defendant has purposefully availed himself of the benefits and protections of the forum state by voluntarily establishing an affiliation with the state. Also determine whether the exercise of jurisdiction is reasonable in light of the state's interest, the burden on the defendant, and the plaintiff's interest in a remedy in the state, among other factors. B. Are the defendant's contacts with the forum state so substantial that he can be subjected to jurisdiction on claims not related to those contacts on a theory of general jurisdiction? Every defendant should have a home base where it is fair that he be subject to suit no matter where the events giving rise to the claim occurred. Particularly with businesses, if defendant's activities in the state are substantial, the court may exercise jurisdiction no matter what the suit is about. C. Has property belonging to the defendant been seized within the state? Seizure of the defendant's property in the state may be a sufficient ground for the exercise of jurisdiction there. However, in order for the property to support the exercise of jurisdiction, it must be related to the claim, either because the property itself is the object of the claim or because the property was involved in the events giving rise to the claim. Seizure of totally unrelated property does not support jurisdiction, except possibly to secure a judgment rendered by a court elsewhere that does have personal jurisdiction over the defendant. D. Has the defendant consented to jurisdiction in the forum state? Consent may result from making a general appearance to defend the case. In some states, a defendant who contests jurisdiction must make a special appearance, raising only the issue of jurisdiction. A defendant may also consent in advance by contract. E. Was the defendant personally served within the forum state? If so, jurisdiction is usually established. The defendant may be able to overcome jurisdiction in very unusual circumstances if his presence in the state was not intentional or knowing. And fraudulent inducement into the state may be a ground for disregarding service. 3. Is venue proper? Besides constitutional limitations on the location of litigation, there are statutory limitations on the venue for suits, often focused on the residence of the defendants. In addition, venue statutes frequently permit suit where the events underlying the suit have occurred. 4. Is another location far superior? Even though the location selected for the suit is not so unreasonable that it is unconstitutional to proceed there, it may be that another location is very clearly superior. If so, a state court may dismiss the case for forum non-conveniens if the preferred forum is in another state or outside this country. Within the federal court system, the court may transfer to a federal court in another state to solve the problem or dismiss if the preferred court is in another country. 5. Was proper notice given? For a court to enter a judgment binding on a defendant, the plaintiff must have made reasonable efforts to give the defendant notice of the lawsuit. Ordinarily, satisfactory notice is given by service of process, the summons to appear before the court and the complaint against the defendant in accord with the pertinent rules or statutes on service. In unusual circumstances, the defendant may be able to argue that the authorized manner of service is not reasonably calculated to provide actual notice, and that entry of judgment would therefore violate due process. A. Introduction. 1. Jurisdiction Historical Perspective 1. In the 19th century, the law on personal jurisdiction focused largely on the power of a state to compel a response to a suit before its courts. Under the prevailing view, in personam jurisdiction could be exercised only if the defendant was personally served with process inside the state. Alternatively, a state could exercise in rem jurisdiction whenever it could seize property of the defendant and use that property to satisfy any resulting judgment. A. Effects of early jurisdiction rules. In operation, these 19th century attitudes toward jurisdiction could produce anomalous results. Unless a defendant had property in a state, he often could not be sued there even if the suit arose from something the defendant had done in the state to a plaintiff citizen of the state. This limitation seemed to constrict jurisdiction too much, and tempted plaintiffs to lure prospective defendants into a state so they could be served there. But courts would often refuse to exercise jurisdiction on the ground that the defendant had been tricked into the state. On the other hand, if the defendant's property could be seized in the state, the court could exercise jurisdiction up to the value of the property, even if the lawsuit had nothing to do with the property and was based on a claim that had nothing to do with the state. Because intangible property such as a bank account could be subject to seizure in a number of places, this method seemed to overextend a state's jurisdiction. B. Limitation by Supreme Court. Eventually, the Supreme Court rejected the requirement for personal service in the state to justify in personam jurisdiction, and ruled that a non-resident defendant could be subject to jurisdiction on a claim related to his contacts with the state if he had minimum contacts with the state. It also curtailed the exercise of in rem jurisdiction based on seizure of property, limiting it to cases in which there is a relationship between the claim and the property. 2. Types of personal jurisdiction 2. Personal jurisdiction, sometimes called territorial jurisdiction, refers to a state's power to hear a case and enforce its judgment over the particular parties or property involved. This power is based on the state's connection to the parties or property. Personal jurisdiction is divided into 3 categories. A. In personam jurisdiction 3. In personam jurisdiction permits a court to enter a judgment that is personally binding on the defendant, either ordering her to do or refrain from doing a certain act equitable or injunctive relief, or decreeing that the plaintiff may collect a certain amount of damages from the defendant legal relief. Courts in other states must enforce such a judgment because the Constitution requires them to give full faith and credit to the judgment. B. In rem jurisdiction 4. In rem jurisdiction permits a court to adjudicate the rights of all possible claimants to a specific piece of property, as in a condemnation proceeding. This authority originated from a state's power to determine controversies regarding real property within its borders. The well-being of every community requires that the title to real estate therein shall be secure, and that there be convenient and certain methods of determining any unsettled questions respecting it. Arndt v. Griggs, 134 U.S. 316 1890. C. Quasi-in rem jurisdiction 5. Quasi-in rem jurisdiction formerly included cases of two types. The first category included cases involving individual disputes related to property under the court's control, such as actions for specific performance of a contract to purchase land. This type of quasi-in rem jurisdiction continues to provide a constitutional basis for the exercise of jurisdiction. The second category of cases involved essentially personal disputes where the court could not assert personal jurisdiction over the defendant, but had jurisdiction over property belonging to the defendant. That property would be seized by the plaintiff and used to satisfy the claim if the plaintiff prevailed. The use of this second category of quasi-in rem jurisdiction to provide a basis for exercise of jurisdiction over non-resident defendants has been severely limited on constitutional grounds. See Infra 6179. 3. Pennoyer v. Neff and the Traditional Power Theory 6. In Pennoyer v. Neff 95 U.S. 714 1 78, the court found that for the state to exercise power over individuals or property, there must be valid service of process on the individual in personam cases or attachment of property in the state in rem actions. The methods by which jurisdiction may be obtained have broadened since Pennoyer. A. The Pennoyer Decision 7. In 1865, Attorney Mitchell sued Neff in an Oregon state court, alleging that Neff owed him about $250 for legal work performed. Neff, a resident of California, was not personally served. Instead, service was by publication based on Mitchell's assertion that Neff owned property in Oregon. When Neff did not appear in the action, Mitchell obtained a default judgment. A month later, Neff acquired title to a tract of land in Oregon, and Mitchell had the sheriff seize and sell the land to satisfy the judgment. Mitchell bought the land at the sheriff's sale and transferred title to Pennoyer shortly thereafter. Many years later, Neff sued Pennoyer in federal court, arguing that the sale was invalid because the Oregon court lacked jurisdiction to enter the judgment against him. The Supreme Court agreed, stating that there had been no in personam jurisdiction over Neff because he was never served with process, and there was no in rem jurisdiction because the court did not attach any Oregon property owned by Neff at the outset of the suit. Thus, the court had no jurisdiction over Neff or his property, and the judgment was invalid. 1. Relation to due process. Because the 14th Amendment did not become effective until 1868, after Mitchell had Neff's property sold, the 14th Amendment due process clause was not involved in the case. However, the court made it clear in dictum that in the future, due process would apply the same limitations on exercise of jurisdiction. B. Territorial limits on Process 8. In keeping with its concept of a state's power being limited by its borders, the court in Pennoyer determined that a state cannot serve an individual domiciled in another state with process and summon that person to respond to a lawsuit against him. This basic limitation on the power of state courts to exercise in personam jurisdiction over out-of-state defendants has been weakened by the modern shift to a minimum contacts analysis. See Infra 2226. C. Methods to obtain jurisdiction. 1. Service within state sufficient. 9. Under Pennoyer, service of process on a defendant within the state is sufficient for jurisdiction. This conclusion is implicit in Pennoyer's reasoning and is the basis for what has come to be known as transient jurisdiction, i.e., a court may obtain jurisdiction over a defendant by serving him when he is temporarily physically present in the state. It has been carried to great lengths. Example service in airplane. Passenger was on a non-stop scheduled commercial airline flight from Memphis, Tennessee, to Dallas, Texas. While the plane was over Pine Bluff, Arkansas, he was served with process. The service was held to be sufficient to establish jurisdiction in Arkansas. Grace v. MacArthur, 170 F. Sup. 442 ed. Arc. 1959. A. Limitation fraudulent inducement into Forum 10. However, courts declined transient jurisdiction where the defendant was fraudulently lured into the jurisdiction. See, e.g., Wyman v. Newhouse, 93F2D 313 2D Sir. 1937 service in Florida was invalid when defendant was enticed to Florida by plaintiff, who falsely told him that she was leaving the country permanently and would like to see him one last time, and see infra. 112. B. Constitutional validity 11. A number of legal authorities questioned the constitutional validity of transient jurisdiction in the wake of Schaffer v. Heitner, 433 U.S. 186 1997 C. Infra, 111, but the Supreme Court has upheld the practice in Burnham v. Superior Court, 495 U.S. 604 1990. 2. Seizure of defendant's property 12. Pennoyer indicated in dictum that prejudgment seizure of a defendant's property was sufficient to permit a state to dispose of that property to satisfy claims not related to the property. Where such seizure was accomplished, the court had power to control disposition of the property, even absent service of process within the jurisdiction. This is an application of the second category of quasi in rem jurisdiction discussed above. See supra 5. A. Need for prejudgment seizure 13. Quasi in rem jurisdiction was not available in Pennoyer itself because in the first action, the plaintiff, Mitchell, did not attach defendant Neff's property before entry of the judgment. The court held that seizure after judgment was insufficient to support jurisdiction. B. Scope of property. 1. Debt as property 14. In Harris v. Bach, 198 U.S. 215 1905. The court upheld assertion of quasi in rem jurisdiction over a debt owed to the defendant by a temporary visitor to the state. The court reasoned that the obligation of the debtor to pay his debt clings to and accompanies him wherever he goes. Therefore, the debt was sufficiently present to permit its seizure to provide a basis for exercise of jurisdiction to the extent of the debt. 2. Insurance policies 15. Some states extended this idea to justify the seizure of an insurer's obligation to defend and indemnify its insured. The obligation was said to be property of the insured, present wherever the insurer could be served, thereby justifying jurisdiction. See Sater v. Roth, 17 NY 2D 111 1966. However, the Supreme Court invalidated this practice in Rush v. Savchuk, 444 U.S. 320 1980 C. Infra, 78. D. Exceptions to in-state service or prejudgment seizure requirement 16. In Pennoyer, the court recognized some exceptions to its rigorous rules. 1. Status 17. Even absent service within the state, the Pennoyer court acknowledged that a state court could determine the status of one of its citizens toward a non-resident. This exception bore principally on divorce cases and gave rise to the Nevada divorce, in which one spouse would move to Nevada for the period required to establish residency and obtain a divorce there. Jurisprudentially, it led to the concept of the divisible divorce, under which the marital status was treated as a res that could be the subject of adjudication by the state in which either spouse resided, but alimony, child support, and other financial matters were viewed as in personam and beyond the authority of a state that had not obtained jurisdiction by personal service. 2. Consent 18. Pennoyer suggested that states could require non-citizens to consent to suit as a condition for conducting activities in the state. As explained in Pennoyer, this depended on the state's right to forbid or exclude the activity. However, there were limitations on the power of a state to exclude non-citizens, and there gradually arose a doctrine of implied consent, which holds that a defendant's in-state activities are sufficient to justify service for suits related to the activities, despite doubts about the power to forbid them. Example: non-resident motorist statutes, in Hess v. Pulaski, 274 U.S., 352 1927. The court upheld jurisdiction based on a statute that treated driving within the state as implied appointment of a local official as defendant's agent for service of process in the state in any suit in that state on claims arising from that driving. E. Notice 19. Pennoyer had an ambivalent attitude toward the need for notice to the defendant of the pendency of the action. 1. Notice not sufficient to establish jurisdiction. 20. The court proceeded from the notion that a state's power over individuals ends at its borders, so that process from a state's courts cannot run into another state and force persons domiciled there to appear in a legal proceeding. Therefore, notice to NEF in California of the suit filed by Mitchell in Oregon would not have any effect on the power of the Oregon court to enter a binding judgment. 2. Notice not required to establish jurisdiction. 21. Pennoyer similarly did not indicate that notice was required for entry of a valid judgment. Instead, it indicated that prejudgment seizure of the defendant's property would be sufficient. Rationale: the law presumes that property is always in the possession of its owner, and therefore its seizure will inform the owner that he must look to any proceedings authorized by law upon such seizure for its condemnation and sale. For examination of the current requirement that notice be given, see Infra 225 et seq. 4. Shift to minimum contacts. 22. In International Shoe Co. v. Washington, 326 U.S. 310/1945, the court shifted away from Pennoyer's insistence on service within the state to support in personam jurisdiction. Instead, it held that to subject a defendant to a judgment in personam, due process requires only that he have certain minimum contacts with the forum such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. A. Systematic and continuous activity. 23. The court has upheld in personam jurisdiction over a non-resident defendant based on systematic and continuous contacts with the state. In International Shoe, the defendant was a Delaware corporation headquartered in St. Louis, Missouri. It employed 11 to 13 salespeople in Washington, who were authorized only to solicit orders. The orders could be accepted or rejected only by the Home Office. Although it had no permanent office in Washington, the sales efforts there generated commissions of at least $31,000 per year. The state claimed that International Shoe was obligated to contribute to the state's unemployment compensation fund in amounts proportional to the activities of its salespeople there. The court upheld Washington's jurisdiction, an easy decision given the volume and systematic and continuous nature of the contacts with the state, as well as the fact that the claim was directly related to the defendant's activities in the state. At some point, such substantial activity may form a basis for holding the defendant subject to general jurisdiction with regard to claims unrelated to its in-state activity. See Infra 80 et seq. B. Single contact. 24. The court has also upheld jurisdiction over a non-resident Texas defendant based on a single contact with the forum California sending a contract for reinsurance to an insured in California. Magee v. International Life Insurance Co. 355 U.S. P. 2019-57. The court emphasized that there was a trend toward expanding the permissible scope of state jurisdiction, based on a fundamental change in the national economy to a more nationalized form of commerce. This reduced the burden on a defendant of defending in any state in which it engages in economic activity. The court indicated that it was sufficient that the contract sued on in Magee had a substantial connection with the state. This conclusion was based in part on the presence in California of witnesses to the company's defense of suicide, and also on the existence of pervasive regulation of insurance companies in California. Magee is regarded by many as a high-water mark for extended state court jurisdiction. C. Purposeful availment limitation. 25. The court cautioned, however, that it is a mistake to assume that this trend heralds the eventual demise of all restrictions on the personal jurisdiction of state courts. Hansen v. Denkla, 357 U.S. 235/1958 in Hansen. The court said that there must be some act by which the defendant purposefully avails itself of the privilege of conducting activities within the forum state, thus invoking the benefits and protections of its laws. D. Post-International Shoe Trend. 26. For 30 years after International Shoe was decided, state courts and legislatures expanded state court jurisdiction. The usual impetus behind such expansions was to provide a forum for local plaintiffs claiming injury due to products or services provided by distant defendants. Given elastic limitations on jurisdiction, there were strong pressures to open the doors of the local courts to such plaintiffs. B. Contemporary constitutional grounds for state court jurisdiction. 1. Contacts with Forum 27. International Shoes approach has generated a two-stage analysis for determining whether the exercise of jurisdiction over a non-resident defendant is proper. The first stage looks to the purposeful availment requirement introduced in Hansen Supra, which is usually the harder requirement to satisfy. If that is satisfied, the analysis turns to questions of reasonableness. A. Purposeful availment minimum contacts 28. This criterion is the requirement on which the Supreme Court has usually relied in overturning overbroad extensions of jurisdiction by the lower courts. Usually, the lower courts justified extensions of jurisdiction on grounds of reasonableness, lack of burden to the defendant, state interest in local adjudication, and convenience to the plaintiff. It is important to keep in mind that, unlike the reasonableness inquiry see infra 4753, the purposeful availment inquiry focuses solely on the activities of the defendant and not on the interests of the plaintiff. 1. Definition. Although far from absolutely clear, the purposeful availment inquiry looks to some voluntary action by the defendant establishing a relationship with the forum, usually one in which the defendant seeks to benefit from the relationship with the forum state. 2. Rationale. This requirement gives defendants fair warning that a particular activity may subject them to the jurisdiction of a foreign sovereign. Burger King Corp. v. Rudzuix, 471 U.S. 462 1985. It thereby gives a degree of predictability to the legal system that allows potential defendants to structure their primary conduct with some minimum assurance as to where that conduct will and will not render them liable to suit. Worldwide Volkswagen Corp. v. Woodson, 444 U.S. 286 1980. Foreseeability 29. Standing alone, the reasonable foreseeability that a suit might be filed in a forum is not sufficient. The foreseeability that is critical to due process analysis is that the defendant's conduct and connection with the forum state are such that he should reasonably anticipate being hailed into court there. Worldwide Volkswagen Corp. v. Woodson Supra. A. Unilateral act of plaintiff insufficient 30. It is said that the unilateral act of the plaintiff in bringing a product to the forum or relocating in the forum is insufficient to establish the requisite connection. Example: relocation to forum. The settlor of a trust lived in Pennsylvania when she set up the trust. The trustee was a Delaware bank. Several years after creating the trust, the settlor moved to Florida. That unilateral act did not justify Florida's assertion of jurisdiction over the Delaware trustee, even though the move was foreseeable. Hansen v. Denkla, Supra, 25. Example: taking product to forum. Plaintiffs bought a car in New York and drove it to Oklahoma, where they were in an accident and suffered severe injuries allegedly caused by a defective design and placement of the car's gas tank. This action by plaintiffs driving the car to Oklahoma did not establish a contact between the New York retail seller and Oklahoma. Worldwide Volkswagen Corp. v. Woodson Supra. B. Entering into a long-term relationship with a forum resident 31. Where the defendant has established a long-term relationship with a forum resident that may suffice to establish minimum contacts. Example: franchise agreement. A Michigan defendant entered into a 20-year franchise agreement with a Florida fast food corporation that required him to adhere to a detailed set of specifications in the operation of his franchised restaurant, to send payments to Florida, and to agree to the application of Florida law in construing the contract. The court stated that Florida jurisdiction was proper because the defendant reached out beyond Michigan and negotiated with a Florida corporation for the purchase of a long-term franchise and the manifold benefits that would derive from affiliation with a nationwide organization. Burger King Corp. v. Rudzuix, Supra. Compare acceptance of corporate directorship. When defendants accepted directorships in a corporation incorporated in the forum state, they may be subject to jurisdiction in that state. See Armstrong v. Pomerantz, 423 A2D 174 Del. 1980. The rationale is that the defendants' status as directors and their power to act in that capacity arise exclusively under the forum state's laws. The Delaware court held that the directors accepted their directorships with explicit statutory notice that they could be hailed into the forum state's courts to answer for alleged breaches of the duties imposed on them by the very laws which empowered them to act in their corporate capacities. C. Seeking to serve 32. In Worldwide Volkswagen, Supra, the court indicated that Oklahoma contacts would have been sufficient to support jurisdiction if it were shown that the defendants regularly sell cars at wholesale or retail to Oklahoma customers or residents, or that they indirectly, through others, serve or seek to serve the Oklahoma market. 1. Single Act 33. A single act seeking to serve the forum market has been held sufficient to support jurisdiction in an action asserting a claim growing out of that act. See McGee v. International Life Insurance Co., Supra, 24. D. Stream of Commerce 34. The court has also said that a forum state may assert personal jurisdiction over a corporation that delivers its products into the stream of commerce with the expectation that they will be purchased by consumers in the forum state. Worldwide Volkswagen Corp. v. Woodson, Supra. 1. Retail Seller 35. In Worldwide Volkswagen, the court held that the stream of commerce ends with the retail sale of the product, even if it is foreseeable that the purchaser will take the product to another state. Note that a retail seller who regularly serves customers from a given state would be said to seek to serve that state's market even if located in another state. 2. Manufacturer or component supplier 36. In Worldwide Volkswagen, the court cited with seeming approval Gray v. American Radiator and Standard Sanitary Corp. 176 NE2D 761 IL. 1961, which upheld jurisdiction over a component supplier whose product was sent into the forum state as part of a product manufactured by its customer. However, the court later failed to resolve a similar issue involving a Japanese component manufacturer and a Taiwanese tire manufacturer whose product failed in California. Asahi Metal Industry Co. v. Superior Court, 480 U.S. 102 1987. Justice O'Connor's opinion in Asahi, not for a majority of the court, indicated that placing a product in the stream of commerce is not sufficient, and that some additional conduct by which the defendant indicates an intent or purpose to serve the forum state is essential. The circumstances under which a manufacturer will be found subject to jurisdiction in a state because its product is sold there remain unclear. E. Targeting or intending effects in Forum 37. The court has indicated that, at least for intentional torts, jurisdiction can be obtained over a non-resident defendant in a forum if the defendant intended that his actions could have an effect in that forum. Calder v. Jones, 465 U.S. 783 1984 court indicated that the editor and author of an allegedly libelous story about a California plaintiff were subject to jurisdiction in California because California is the focal point, both of the story and of the harm suffered. 1. Generally focused on wrongful or commercial activity 38. The court has stated that the effects test above was intended to reach wrongful activity outside of the state causing injury within the state or commercial activity affecting state residents. Colco v. Superior Court, 436 U.S. 84 1978. Example: in Colco, an ex-wife moved from New York to California and then sued her New Yorker ex-husband in California to modify child custody and child support arrangements. See Supra 17, regarding divisible divorce. The court held that the ex-husband's act of buying the couple's daughter a ticket to move to California, at her request, was not sufficient to support California jurisdiction. Even though the ex-husband could have foreseen effects there, the court reasoned that the ex-husband did not purposefully derive any benefits from activities related to California, and he had no other relevant contact with California. Thus, he could not reasonably anticipate being hailed into court there. Compare a lower court upheld California jurisdiction over French defendants who obtained a French court order directing a California internet service provider to take actions in California or face significant financial penalties. The French litigants were found to have sufficient contact with the forum state of California based upon the French order to satisfy the purposeful availment test. Yahoo, Inc. v. La Ligue contre le racisme et l'antisémitisme. 433 F3D 1E 99 9th Sir. 2005, we do not read Calder necessarily to require in purposeful direction cases that all or even any jurisdictionally relevant effects have been caused by wrongful acts. 2. Not applicable to all intentional torts 39. The effects test may not apply to all intentional torts. See IMO Industries, Inc. v. Kiekert Ag. 155 F3D 254 3D Sir. 1998 For jurisdiction to be upheld, plaintiff must have felt brunt of harm of intentional tort in forum, and defendant must have expressly aimed its conduct at the forum. 4. Relationship between contacts with forum and claim asserted 40. The Supreme Court has assumed that jurisdiction is proper for claims related to the forum contacts that satisfy the purposeful availment requirement. This involves what has been called specific jurisdiction. See Burger King Corp. v. Rudzuix, Supra, 28 for a discussion of the concept of general jurisdiction. See Infra, 8092. However, some cases present difficult problems that are often raised on examinations. Consider the following cases where the claim was not directly related to the forum contacts. Example: recall that in Worldwide Volkswagen Corp. v. Woodson, Supra, the plaintiffs purchased an Audi in New York, drove it to Oklahoma, were involved in an accident in Oklahoma, and alleged that they were injured because of design defects in the Audi. It seemed to be assumed that Oklahoma had specific jurisdiction for the plaintiff's claim over Audi, the German manufacturer, and Volkswagen of America, the importer of Audi cars for the entire country, because both seek to serve the Oklahoma market. However, it is difficult to see how the plaintiff's claim was related to Audi's and VW's contacts with Oklahoma, i.e., their efforts to serve Oklahoma, since the Audi in question was sold in New York. Example: in Buckeye Boiler Co. v. Superior Court, 71 Cal. 2D 893 1969. The plaintiff was injured in California by the explosion of a boiler manufactured by the defendant. The defendant regularly supplied boilers to a California purchaser, but these were of a different type from the one that injured the plaintiff, and nobody could explain how that boiler got to California. The California court upheld jurisdiction, finding that the plaintiff's cause of action appeared to arise from the defendant's economic activity in California, the totality of its sales of tanks to California customers or to other customers for foreseeable resale or use in California. A. Possible resolution. One resolution of this problem of similar claims not evidently connected with the forum contacts is to focus on the foreseeability elements mentioned above. See Supra 2930. If the claim actually asserted is of the type the defendant should have foreseen in the forum, it is not unfair to subject the defendant to jurisdiction even if this particular claim does not arise from the defendant's contacts. See Twitchell, The Myth of General Jurisdiction, 101 Harv. L. Rev. 610, 661, 62, 1988. However, consider the tricky problem of what constitutes adequate similarity. Must it be the identical product that is distributed? A similar make or model? Would assertion of specific jurisdiction require that a similar product sent into the forum state have an identical defect? Brillmeyer, Related Contacts and Personal Jurisdiction, 101 Harv. L. Rev. 144 and 44, 1988. 5. Commercial vs. Non-commercial 41. purposeful availment may be found more easily with regard to a defendant's commercial activity than with regard to non-commercial activity. In assessing a defendant's contacts with the state, it is significant whether a defendant seeks commercial benefit from solicitation of business from a resident of the forum state. Example franchising agreement. In Burger King, Supra, the defendant, a Michigan citizen, dealt face-to-face with the Michigan office of Burger King regarding opening a Burger King franchise in Michigan. However, he also negotiated via telephone with the Florida headquarters and agreed to send payments and notices there. Noting that the defendant was a commercial actor, the court held that the Florida contacts constituted purposeful availment and thus upheld jurisdiction at Burger King's home in Florida. Compare suits against consumers. In Burger King, the court indicated that suits against consumers to collect payments due on personal purchases would not be permitted at the distant sellers' locations as this was not commercial. Activity by the consumers. Compare family law. A court is less likely to find minimum contacts when the defendant has not sought any commercial benefits from contacts with the forum. Thus, the court held that a divorced father who sent his daughter to live with his ex-wife did not thereby become subject to California jurisdiction in an action to modify support and child custody arrangements. The court reasoned that a father who agrees, in the interests of family harmony and his children's preferences, to allow them to spend more time in California than was required under a separation agreement can hardly be said to have purposefully availed himself of the benefits and protections of California's laws. Colco v. Superior Court, Supra, 38. 6. Choice of law distinguished 42. The court has repeatedly emphasized that the fact that a given state's law may apply to a case under its conflict of laws rules is not relevant to the issue of whether the purposeful availment requirement is satisfied. Colco v. Superior Court. Supra fact that California may be the center of gravity for choice of law purposes does not mean that California has personal jurisdiction over the defendant. A. Distinguished choice of law, Clause 43. However, the party's election that a certain state's law will govern their relations may support jurisdiction in that state. Thus, in Burger King, Supra, the court stated that the inclusion of a provision selecting Florida law in the party's contract, although not sufficient of itself to support jurisdiction, reinforced defendant's deliberate affiliation with Florida. 7. No relation to federalism 44. The Supreme Court has sometimes suggested that the limitations on personal jurisdiction are related to principles of interstate federalism, specifically to issues of a state's sovereignty vis-à-vis other states. See Worldwide Volkswagen Corp. v. Woodson, Supra. 40. However, the court has since stated that the requirement of personal jurisdiction ultimately arises from the Due Process Clause and is unaffected by notions of federalism. If it were otherwise, it would not be possible for a defendant to waive the personal jurisdiction requirement, because this would interfere with state sovereignty. See Insurance Corp. of Ireland, Limited, v. Compagnie des Bauxites de Guinée, 456 U.S. 694 1982. 8. Reasonableness insufficient to satisfy purposeful availment requirement 45. The court has rejected the idea that other factors can outweigh the importance of the purposeful availment requirement, even if the defendant would suffer minimal or no inconvenience from being forced to litigate before the tribunals of another state, even if the forum state has a strong interest in applying its law to the controversy, even if the forum state is the most convenient location for litigation. The Due Process Clause may sometimes act to divest the state of its power to render a valid judgment. Worldwide Volkswagen Corp. v. Woodson, Supra. B. Fair play and substantial justice reasonableness 46. Besides focusing on the defendant's contacts with the forum, the jurisdictional inquiry takes account of a number of other factors that bear together on whether the exercise of jurisdiction in the state is reasonable. On this question, consideration of the plaintiff's interests is proper. 1. Factors 47. The Supreme Court has identified a variety of factors that may bear on the reasonableness of jurisdiction. A. The burden on the defendant to defend the litigation in the forum. B. The forum state's interest in adjudicating the dispute. C. The plaintiff's interest in obtaining convenient and effective relief. D. The interstate judicial system's interest in obtaining the most efficient resolution of the dispute. And E. The shared interest of the several states in furthering fundamental substantive social policies. 2. Overlap 48. The same facts may be relevant to more than one of the above factors. For example, if the action arises out of an injury to the plaintiff in the forum, that may bear on the state's interest in adjudicating the dispute, and on the plaintiff's interest in obtaining convenient and effective relief, given the supposed presence in the forum of important witnesses to the event. Similarly, the judicial system's interest in efficient resolution of the dispute could favor local resolution where potential witnesses are located, and also could favor local resolution if there are local defendants who could not be sued elsewhere, a factor that would also bear on the plaintiff's interest in effective relief. The fact that the injury occurred outside the forum state may indicate not only that witnesses are not conveniently located, but also that the primary substantive interests involved are those of the state where the event occurred. 3. Non-critical 49. The fact that certain factors do not support forum jurisdiction is not fatal to jurisdiction. Thus, for example, the plaintiff need not be local for jurisdiction to be valid. Keaton v. Hustler Magazine, Inc., 465 U.S. 770 1984. Similarly, the fact that the defendant has conducted only one piece of business in the state does not by itself defeat jurisdiction over a claim arising out of that business. McGee v. International Life Insurance Co., Supra, 33. 4. Easy to satisfy 50. Where a defendant who purposefully has directed his activities at forum residents seeks to defeat jurisdiction, he must present a compelling case that the presence of some other considerations would render jurisdiction unreasonable. Burger King v. Rudzuix, Supra, 43. Example, in Keaton v. Hustler Magazine, Inc., Supra, plaintiff sued in New Hampshire after her first suit in Ohio was dismissed. She had no prior contact with New Hampshire, but sued there only because the limitations period had expired in all other states. The court found that the defendant's regular sale of 10,000 to 15s and magazines in the state constituted purposeful availment and upheld jurisdiction as reasonable even though the plaintiff sought to recover damages for defamation worldwide under the single publication rule. See torts. Summary. 5. Greater concern with burden on foreign defendants 51. The court has indicated that it may be relevant that the defendant is a foreigner, recognizing the unique burdens placed upon one who must defend oneself in a foreign legal system. Asahi Metal Industry v. Superior Court, Supra, 36. Example, in Asahi, the court held that it was unreasonable for California to exercise jurisdiction over a cross-complaint for indemnity by a Taiwanese manufacturer against a Japanese component manufacturer. In addition to the extra burdens placed on foreign defendants, the court placed weight on the fact that the California plaintiff had settled his claim, leaving only the indemnification claim to be decided, and that it could be decided equally conveniently in Japan or Taiwan, where the dealings between the parties occurred. A. Caution. It is not clear whether Asahi indicates that as a general matter there is greater concern with the reasonableness of jurisdiction over foreign defendants. It may be that the court would have viewed things differently had the California plaintiff been pursuing a claim against the Japanese component manufacturer who objected to jurisdiction. 6. First Amendment concerns 52. Some lower courts felt that in certain defamation cases the risk of chilling the exercise of First Amendment rights warranted more demanding scrutiny of the reasonableness of jurisdiction. However, in Calder v. Jones, Supra, 37, the court rejected this reasoning. The potential chill on protected First Amendment activity stemming from libel and defamation actions is already taken into account in the constitutional limitations on the substantive law governing such suits. To reintroduce those concerns at the jurisdictional stage would be a form of double counting. C. Application Internet Activities 53. The greatly increased use of the Internet in recent years has begun to produce rulings on the scope of personal jurisdiction in resulting litigation. Because this is a recent development, this is an evolving area and the emerging rules remain unclear. For purposes of illustration, however, some specifics can be provided. 1. Same general analysis applied 54. The same minimum contacts analysis that is used for other litigation applies to suits arising from Internet activities as well. See Supra 22. A. Contracts via Internet 55. As in Burger King Supra 28, entering into an ongoing contract via Internet communications usually will suffice to support jurisdiction at the forum of either party for an action alleging breach of contract against the other. See CompuServe, Inc. v. Patterson, 89 F3D 157 6th Sir, 1996. Ohio jurisdiction proper in suit based on software distribution agreement entered into online between Ohio plaintiff and Texas defendant. B. Causing effects in forum via Internet activities may suffice 56. Activities via the Internet have been reviewed under the effects test of Calder Supra 37 to determine whether the defendant should have realized that the effect in the forum would lead to suit there. Example: a federal court held that D.C. had jurisdiction over a defamation suit against a California-based electronic gossip columnist. Because numerous D.C. readers had the defendants' column emailed to them, reader contributions from D.C. were solicited, stories in the column focused on D.C., and the defendant visited D.C. to promote the column. Blumenthal v. Drudge, 992 F. Sup. 44 DDC, 1998. Compare: the California Supreme Court held that a college student who posted a program that could be used to duplicate DVDs, despite encryption designed to prevent duplication, did not sufficiently target California entertainment companies or the California computer industry to permit a California court to exercise jurisdiction in a suit for an injunction against alleged misappropriation of the program. Pavlovich v. Superior Court, 29 Cal. 4th 262-22. C. Relation to State Long-Arm Statute Requirements 57. Courts apply their usual long-arm analysis when determining personal jurisdiction in Internet cases. A state has long-arm jurisdiction when the defendant commits an act enumerated in the long-arm statute and thereby submits to the state's personal jurisdiction for any cause of action arising out of that act. See Infra 119. See, e.g., Bensusan Restaurant Corp. v. King, 126 F3D 25 2D Sir. 1997 alleged trademark infringement on passive web page set up in Missouri did not constitute tortious act committed in New York under its long-arm statute. Compare Blumenthal v. Drudge. Supra defendant's interactive web page satisfied long-arm statute in defamation case due to the impact of the story in D.C. and to defendant's persistent course of conduct consisting of contacts with forum residents in connection with subjects addressed on the web page, as well as solicitation of information from D.C. residents for use in the online column. 2. Specific issues relating to Internet. A. Ability of forum residents to access Internet site usually not sufficient 58. Most courts hold that the ability of forum residents to access a web page does not, standing alone, support forum jurisdiction. See GTE New Media Services, Inc. v. BellSouth Corp. 199 F3D 1343 DC. Sir, to know in fact that forum residents could access defendant's web page was not sufficient to uphold jurisdiction. Compare Inset Systems, Inc. v. Instruction Set, Inc. 937 F. Sup. 161 D. Con. 1996 Foreign corporations advertising via Internet was solicitation of sufficient repetitive nature to satisfy solicitation of business provision of long-arm statute. B. Level of interaction and nature of web page relevant 59. Courts often look to the level of interaction of a web page to determine whether or not the purposeful availment requirement has been met. If the web page is passive, e.g., merely provides information, jurisdiction will usually not be found. See Bensusan Restaurant Corp. v. King. Supra Local Missouri Club with web page could not be subject to trademark suit under New York long-arm statute by New York Club with same name. Even a web page that permits interaction may not support jurisdiction if it is essentially local in nature. See Millennium Enterprises, Inc. v. Millennium Music, LP, 33F, Sup. 2D 907D, or 1999 Defendant's interactive web page about its retail outlets in North Carolina insufficient to support jurisdiction in Oregon because content was essentially local, and when it became aware of plaintiff's trademark concerns, defendant posted notice saying it would not fill orders from Oregon. 1. Criticism. Certain passive websites may still be said to target the forum. Consider, e.g., an imaginary website www.bombthebridge.org, containing the plans for the construction of the Golden Gate Bridge, detailed instructions on how and where to place bombs to destroy the bridge, and specific instructions on how to build such bombs. Even if such a website were entirely passive, a court might well hold that it targeted San Francisco. 3. Possible relaxation of reasonableness requirement 60. Because communication via the Internet is easier than by other means, the advent of this new mode of communication may cause courts to relax the reasonableness requirements. See McGee v. International Life Insurance Co. Supra 24 in upholding jurisdiction. Court emphasized the fundamental transformation of our national economy, and the fact that modern transportation and communication have made it much less burdensome for a party sued to defend himself in a state where he engages in economic activity. 2. Presence of defendant's property in Forum 61. Quasi-in rem and in rem jurisdiction have been curtailed since Harris v. Bach, Supra. 14. Nevertheless, the presence of the defendant's property in the jurisdiction often may suffice to make jurisdiction constitutional, but ordinarily only because it establishes a relevant contact between the defendant and the forum. A. Location of property. 1. Tangible property 62. Tangible property, e.g., real estate, chattels, is located in a state if it is physically present therein. 2. Intangible property 63. Generally, states may declare that intangible property is located within their jurisdiction if some transaction related to the property occurred within the state. When intangible property is embodied in an instrument, e.g., negotiable paper, however, it is usually said to be located in the state where the instrument is located. Examples: a debt such as a bank account may be deemed located where the debtor the bank is located, but generally shares of stock are said to be located where the certificate is located. A. Absence of constitutional limitations 64. The court has placed no constitutional limitations on the power of a state to declare intangible property present within its borders. It has upheld multiple death taxation of property by different states that all claim the property is within their jurisdiction. Blackstone v. Miller, 188 U.S. 189-93, but has held that when a debt may be located in more than one state, due process forbids a state from declaring the property escheated unless it can guarantee that no other state would make a conflicting and duplicative claim. Western Union Telegraph Co. v. Pennsylvania, 368 U.S. 71-1961. Example: corporate stock in Schaffer v. Heitner, Supra, 11, Delaware, unique among the 50 states, declared that shares of stock in corporations it chartered were located in that state rather than where the certificate was located. The court did not question this. Example: insurer's duty to defend and indemnify in Rush v. Savchuk, Supra. 15. The court did not question the state's conclusion that the insurer's obligation to defend and indemnify the insured constituted property in the state, while holding net contact insufficient to support jurisdiction. B. Contacts Test 65. Schaeffer held that the minimum contacts analysis of international shoe should be applied to jurisdiction over property, reasoning that jurisdiction over a thing is an elliptical way of referring to jurisdiction over the interests of persons in a thing, and should therefore be viewed as analogous to personal jurisdiction in terms of protection of those interests. C. Presence of property supports jurisdiction 66. In Schaeffer, the court recognized that the presence of property in a state may bear on the existence of jurisdiction by providing contacts among the forum state, the defendant, and the litigation. 1. True in rem cases 67. The court appeared to leave untouched the state's power to exercise true in rem jurisdiction, which affects the interests of all persons in designated property. Therefore, the state would have jurisdiction based on the presence of the property in true in rem cases, e.g., condemnation. 2. Pre-existing claim to property 68. Actions for specific performance or otherwise to perfect a claim to the property, e.g., actions to remove a cloud on title, should also still be permissible in the state where the property is located. A. But note: this reasoning would not necessarily apply to an action by the owner of local property to force a non-resident to perform an alleged contract to purchase the property, as the presence of the property may not imply any connection between the defendant and the state. B. Must be claimed to specific property 69. Note that the legal right asserted must be to recover the specific property located in the forum state, such as in a replevin action. Property attached as security for an eventual money judgment would not suffice. 3. Claim related to rights and duties arising from ownership 70. The court also noted that jurisdiction could be sustained on the basis of presence of the property where the claim relates to the duties of the owner. Example: in Dubin v. Philadelphia 32 Pa. D. and C. 61 1938. Jurisdiction was upheld in a suit against an absentee owner of property for injuries sustained on the property. The court reasoned that it is just as important that non-resident owners of Philadelphia real estate should keep their property in such shape as not to injure our citizens as it is that non-resident owners of cars should drive about our streets with equal care. It is only a short step beyond this to assert that defendants in both classes of cases should be answerable in this forum. A. Movable property 71. Note that injuries may be inflicted by movable property, such as construction equipment or an airplane. If that produces a claim against the owner, seizure of the property may support jurisdiction even if the owner did not cause the property to be in the forum, e.g., because the property was leased. B. Distinguish property unrelated to Claim 72. In Rush v. Savchuk, Supra, the court held that the presence of property, the insurer's obligation to defend and indemnify the insured, was jurisdictionally insignificant since the insurance policy is not the subject matter of the case, nor is it related to the operative facts of the negligence action. 4. Real property 73. Justices Powell and Stevens argued in concurring opinions that Schaeffer should not invalidate jurisdiction in actions against non-resident owners of real property in the state. 5. Absence of another forum 74. In a footnote in Schaeffer, the court noted that this case does not raise, and we therefore do not consider, the question whether the presence of a defendant's property in a state is a sufficient basis for jurisdiction when no other forum is available to the plaintiff. This may sanction jurisdiction by necessity. Example: in Mullane v. Central Hanover Bank and Trust Co., 339 U.S. 306 1950, the court upheld New York jurisdiction to determine the interests of all beneficiaries, including claims of mismanagement by the trustee in trusts established in New York, without examining the beneficiary's personal affiliation with New York. eschewing an attempt to categorize this jurisdiction as in rem or in personam. The court reasoned that the interest of each state in providing means to close trusts that exist by the grace of its laws and are administered under the supervision of its courts is so insistent and rooted in custom as to establish beyond doubt the right of its courts to determine the interests of all claimants, resident or non-resident, provided its procedure affords full opportunity to appear and be heard. The scope of this jurisdiction by necessity is unclear. 6. Securing judgment in another forum 75. In Schaffer, the court rejected the argument that quasi-in rem jurisdiction is necessary to prevent a defendant from moving his assets to a state in which he is not subject to suit. The court suggested that in such a situation it might be proper for the plaintiff to attach the property as security for a judgment being pursued in a state that has in personam jurisdiction over the defendant. For an example, upholding jurisdiction to attach defendant's assets pending judgment in a jurisdiction that has personal jurisdiction over defendant. See National Union Fire Insurance Co. v. Kozang, 115F, Sup. 2D1 and 231D. Colo, 2000. 7. Enforcing valid judgment 76. Similarly, the court noted that once a judgment is entered by a court within personam jurisdiction, it is proper for another state to enforce the judgment, even if it did not have jurisdiction to decide the case as an original matter. See Schaffer v. Heitner, Supra. D. Presence of unrelated property insufficient for jurisdiction 77. Schaffer holds that when property is completely unrelated to the plaintiff's cause of action, its presence alone will not suffice to support jurisdiction. This overrules Harris v. Bach, Supra, 14. E. Insurance Obligations 78. States cannot obtain jurisdiction over non-resident defendants in automobile tort actions by treating the defendant's insurer's obligation to defend and indemnify as property in the state and garnishing the insurer. Rush v. Savchuk, Supra, 72. F. In personam alternative 79. Whenever the defendant may be subject to in rem jurisdiction, it is important to consider in personam jurisdiction as well. Example, in Schaffer, Justice Brennan, while agreeing that international shoe should be applied to quasi-in rem jurisdiction, argued that the defendant's acceptance of positions as officers or directors in Delaware corporations should support jurisdiction over them in Delaware. After the decision in Schaffer, the Delaware legislature promptly enacted a statute so providing, and such exercise of in personam jurisdiction was upheld. Armstrong v. Pomerantz, Supra, 31. 3. General jurisdiction. A. Introduction 80. The Supreme Court distinguishes between specific and general personal jurisdiction. If general jurisdiction is justified, the defendant is subject to suit on any claim in the forum. Specific jurisdiction, on the other hand, gives rise to jurisdiction only for claims related to the jurisdictional contact with a state. See Burger King Corp. Rudzowick's, Supra, 28. 1. Relation to Claim 81. The general jurisdiction analysis usually becomes important when the relation between the defendant's contacts with the jurisdiction and the claim sued upon is not sufficient for specific jurisdiction. See Supra, 40. For purposeful availment, focus on relation between contacts and claim. Where there is not a sufficient relation between the contacts and the claim, one may look for a basis to exercise general jurisdiction. Example, in Helicópteros Nacionales de Colombia v. Hall, 466 U.S., 408 1984, the plaintiffs sued in Texas to recover for the deaths of workers killed in a helicopter crash in Peru. The helicopter was operated by the defendant, a Colombian company. The parties conceded that the claims did not arise out of the defendant's contacts with Texas, so there was no basis for specific jurisdiction. Neither did the court find a basis for general jurisdiction. Justice Brennan dissented, arguing that the claims were sufficiently related to the defendant's Texas contacts to permit specific jurisdiction because the defendant negotiated the contract it was performing in Texas, bought in Texas the helicopter that crashed, and sent its pilots to Texas for training, but the majority did not agree. Rationale: since international shoe forbids jurisdiction only where it would violate fair play and substantial justice for the state to exercise jurisdiction, one might well question the need for general jurisdiction in other cases. The general idea is to provide a safe harbor where the plaintiff may bring suit without the worry that a court might later question the existence of sufficient contacts under international shoe. A. Comment: possible narrowing of general jurisdiction. Although the threshold for general jurisdiction is relatively low, particularly for corporate defendants, the expansion of specific jurisdiction may call for a more cautious use of general jurisdiction. See Nichols v. G.D. Cyril & Co., 991 F2D 1N 195 4th Sir, 1993. Because specific jurisdiction has expanded tremendously, general jurisdiction, which functioned primarily to ensure that a forum was available for plaintiffs to bring their claims, has been rendered largely unnecessary. Thus, broad constructions of general jurisdiction should generally be disfavored. B. Natural persons 82. General jurisdiction is available in the state of a person's domicile. Milliken v. Mayer, 311 U.S. 457 1941 acquires a domicile by being present in a state with the intent to make it one's home for an indefinite period. Distinguish diversity of citizenship subject matter jurisdiction. Domicile is also important for determining diversity of citizenship in connection with the subject matter jurisdiction of federal courts. See Infra 325. Be sure to keep the concepts of personal jurisdiction and subject matter jurisdiction separate. See Corporations 83. A corporation is subject to general jurisdiction in its state of incorporation and in the state in which its headquarters are located, if different from its state of incorporation. This may produce problems if the executive offices are in one state and the manufacturing headquarters are in another. See Infra 328 at Sec. Regarding citizenship of corporation for diversity purposes. Substantial contacts 84. Corporations have been held subject to suits on unrelated claims in states in which they conduct substantial activity. The level of activity that is sufficient for this purpose is ambiguous. Although one could argue that only a very large volume of activity should suffice, some courts have seemingly lowered the threshold. A number of examples provide touchstones. Temporary headquarters in Forum 85. In Perkins v. Banked Consolidated Mining Co., 342 U.S. 437 1952, a Philippine corporation was unable to operate due to the Japanese occupation of the Philippines during World War II. Its president and general manager maintained an office in Ohio that seems to have functioned as a substitute head office. The court stated that defendant had functioned as carrying on in Ohio a continuous and systematic, but limited, part of its general business. Jurisdiction in Ohio was upheld. Ongoing operations in Forum 86. In older cases, even a relatively small office of a defendant corporation would suffice to uphold general jurisdiction, but courts may be tightening those requirements. Office in Forum Sufficient 87. In Bryant v. Finnish National Airline, 15 NY2D 426 1965, the New York Court of Appeals upheld jurisdiction over a claim for injuries sustained in Europe based on defendant's operation of a 1.5-room office in New York, staffed by 3 full-time and 4 part-time employees, and maintenance of a bank account in New York, even though defendant had no flights to or from American airports. Distinguished sales in Forum not sufficient 88. In Nichols v. G.D. Cyril & Co., Supra 81, 116 plaintiffs from other states sued Cyril in Maryland, basing jurisdiction on the fact that although Cyril had no office in the state, it did have 17 to 21 employees regularly working there to market its products, resulting in annual sales of $913 million in the state. But the court found these activities insufficient to justify general jurisdiction. Problem nationwide business activities 89. In Rush, Supra 78, The Supreme Court stated that State Farm Insurance Co. was subject to garnishment in Minnesota because State Farm is found in the sense of doing business in all 50 states. The propriety of basing general jurisdiction over companies with nationwide business activities is unclear. Distinguish purchase of equipment and execution of contract in Forum 90. In Helicópteros Nacionales de Colombia v. Hall, Supra, 81, the defendant, a Colombian corporation, had contracted to provide transportation services in Peru, in connection with a project being built there by a Texas-based joint venture, and had been paid over $5 million for its services under the contract. The defendant had also purchased most of its helicopter fleet from a Texas manufacturer and sent its pilots to Texas for training. The court held the defendant's contacts with Texas to be insufficient as a basis for general jurisdiction over the defendant. Regular purchases in Forum 91. Similarly, in Rosenberg Bros. & Co. v. Curtis Brown Co., 260 U.S., 516-1923, an Oklahoma retailer's purchase of a large portion of its merchandise in New York was held not to be sufficient for jurisdiction, even when coupled with regular visits to New York in connection with the purchases. The Supreme Court cited this case with approval in Helicópteros. Possible reasonableness limitation 92. In Metropolitan Life Insurance Co. v. Robertson Seco Corp., 84 F3D. 562D Sir, Cert. Denied, 519 U.S. 116-1996. The court found that the defendant manufacturer had systematic and continuous contacts with the state so as to satisfy general jurisdiction, but still declined jurisdiction, finding that the exercise of jurisdiction over the manufacturer was unreasonable because there was no cognizable interest in the forum on the part of the plaintiff or the state. Criticism: because the common law doctrine of forum non-convenience, infra 207, is available to support dismissals for inconvenience, holding jurisdiction unconstitutional on reasonableness grounds, even when suit is brought at corporate headquarters, seems dubious. 4. Consent 93. A defendant may consent to jurisdiction in the forum. This consent may be express, implied, or due to the making of a general appearance in the minority of states that do not follow federal practice. A. Express consent 94. Express consent can be made either before or after suit is filed, and suffices to support jurisdiction without reference to other contacts with the forum. Example: in National Equipment Rental, Limited, v. Shukant, 375 U.S. 311-1964, Michigan farmer defendants signed the plaintiff's form lease for farm equipment, providing that one Florence Weinberg of Long Island would be their agent for service of process in New York. The defendants did not know Weinberg, who was the wife of an officer of the plaintiff, but the court upheld the effectiveness of service on her to establish jurisdiction in New York. Registration by Corporation 95. In many states, foreign corporations that engage in business in the state are required to register and appoint an agent for service of process in the state, thereby consenting to suit there. A. Commerce Clause Limitations 96. The power of a state to insist on consent to general jurisdiction may be questionable to the extent that it unreasonably burdens interstate commerce. Compare Pennsylvania Fire Insurance Co. v. Gold Issue Mining and Milling Co. 243 U.S. 93-1917 state could require corporations wishing to do business to consent to jurisdiction on unrelated claims with Bendix Autolite Corp. v. Midwestco Enterprises, Inc., 486 U.S. 888-1988 state may not deny protection of statute of limitations to foreign corporation that refuses to consent to jurisdiction on unrelated suits. B. Implied consent contrasted 97. As an adjunct to the registration requirements, states often treat conduct of business in the state to be implicitly appointing a state official, often the Secretary of State, as agent for service of process. This is not based on a true consent theory, but on the constitutionality of exercise of state jurisdiction over claims arising from the corporation's activities in the state. Limitation Local Actions 98. In cases involving title to land, courts will proceed only if the land is located in the jurisdiction. See Infra 175. In such cases, consent of the parties is insufficient. B. Implied Consent 99. By filing suit, the plaintiff is deemed to have consented to the jurisdiction of the forum for the purpose of a counterclaim by the defendant. Adam v. Singer, 303. U.S. 59, 1938. However, this implied consent does not extend to a counterclaim unrelated to the subject matter of the plaintiff's claim against the defendant. 1. Consent in Class Actions 100. In class actions, the failure of unnamed plaintiff class members to opt out of the class action constitutes consent to adjudication of their claims in the forum. Phillips Petroleum Co. v. Schutz, 472 U.S. 797, 1985. The Supreme Court has not resolved the question of whether the same reasoning would apply to a defendant class. C. Appearance 101. A party's voluntary appearance in an action is sufficient by itself to support jurisdiction. What constitutes an appearance? 102. In general, an appearance occurs when the defendant defends litigation on the merits. Depending on the prevailing rules in the jurisdiction, the issue turns on the extent to which the defendant raises issues other than jurisdiction. A. State Courts 103. In many states, a defendant who wishes to preserve objections to personal jurisdiction must make a special appearance raising only jurisdictional issues. Raising any other matter subjects the defendant to the risk of having made a general appearance and thereby consenting to jurisdiction. In some states requiring a special appearance, however, the defendant may simultaneously raise other defenses so long as it immediately challenges personal jurisdiction. See, e.g., Cal. Civ. Proc. Code 418.10 defendant who files a motion to quash service of process challenging personal jurisdiction may simultaneously answer, demur, or move to strike the complaint without waiving its objection to jurisdiction. Federal Courts 104. In federal courts and in most state courts, a defendant need not make a special appearance. All grounds of defense, including lack of personal jurisdiction, can be asserted in a motion or answer. See Fed. R. Civ. P. 12b. Waiver 105. However, if the defendant fails to raise personal jurisdiction in her initial motion or answer, that objection is waived. Fed. R. Civ. P. 12h1. Consent to jurisdiction to decide jurisdiction 106. By moving to dismiss for lack of personal jurisdiction, the defendant consents to the power of the court to decide that question, including the power to order discovery pertinent to the jurisdictional question. Insurance Corp. of Ireland Limited v. Compagnie des Bauxites de Guinée, Supra, 44. Binding effect 107. A defendant who appears and litigates jurisdiction may not later raise jurisdiction as a bar to full faith and credit. See Infra 141. To preserve the jurisdictional objection as a ground for resisting full faith and credit, defendant must default. See Infra 109. Extent of jurisdiction conferred 108. A general appearance may be limited to the claims made or issues raised in the action at the time of the appearance. D. Alternative of default 109. A defendant who believes that jurisdiction in the forum is improper may disregard the suit and permit a default judgment to be taken against him. When the plaintiff later attempts to enforce the default judgment in another jurisdiction under the full faith and credit clause, the defendant can then challenge on the ground that the rendering court lacked jurisdiction. If the enforcing court finds jurisdiction was proper, however, there will be no further opportunity to defend on the merits. See Infra 138. 5. Service within the jurisdiction 110. Under Pennoyer, Supra 6, service of process within the jurisdiction was presumptively sufficient to support jurisdiction. A. Possible minimum contacts requirement 111. In Schaffer, Supra 65, the court stated that All assertions of state court jurisdiction must be evaluated according to the standards set forth in International Shoe. However, in Burnham v. Superior Court, 495 U.S. 604/1990, the Supreme Court, without a majority opinion but with no dissents, upheld the constitutionality of transient jurisdiction obtained by service on a non-resident temporarily within the state, even though the suit was unrelated to the defendant's activities in the state. Caution: this ground for jurisdiction may not suffice, according to some justices' opinions, if the defendant's presence in the state was not intentional or voluntary. B. Fraudulent inducement 112. Where the defendant is personally served in the forum state, the court will not exercise jurisdiction on that ground if the defendant was lured into the jurisdiction by the plaintiff's false statements. See Wyman v. Newhouse, Supra, 10. Distinguished trickery to effect service 113. Although fraudulently inducing a defendant into the jurisdiction is generally a defense to the assertion of jurisdiction on the basis of that service, using trickery to effect service on a defendant already in the jurisdiction generally does not interfere with the effectiveness of service. In rem cases 114. When the plaintiff relies on seizure of the defendant's movable property to establish jurisdiction, the seizure should be disregarded if the property is moved to the forum as the result of some trickery by the plaintiff. See Commercial Air Charters v. Sundorf, 57 FRD, 84D. Con. 1972 jurisdiction refused because plaintiff's friend rented defendant's airplane, misrepresenting his intentions, and took it into forum so that plaintiff could levy attachment. 6. Territorial jurisdiction of federal courts 115. In most cases, federal courts do not exercise nationwide jurisdiction, except in a few situations where such powers are conferred by rule or statute. The territorial jurisdiction of a federal court is usually no broader than that of the state in which the federal court is located. See Infra 127 et sec. A. Constitutional limitations on nationwide service 116. It appears that Congress could constitutionally create nationwide personal jurisdiction for the federal courts. See United States v. Union Pacific Railroad, 98. U.S. 569 1878, asserting that Congress could have created a single federal district court with nationwide jurisdiction. There may, however, be limitations under the Due Process Clause of the Fifth Amendment on extremely inconvenient exercises of jurisdiction. Compare Republic of Panama v. BCCI Holdings, 119 F3D 935 11th Sir. 1997, finding nationwide exercise of jurisdiction subject to Fifth Amendment due process limitations with FTC v. Jim Walter Corp., 651 F2D 251 5th Sir. 1981, rejecting Fifth Amendment limitation on federal court jurisdiction. B. National Contacts 117. Some have argued that in actions against aliens, contacts with the United States should be aggregated in order to determine whether together they would support jurisdiction in this country, even though no one state has sufficient contacts to justify jurisdiction. The Supreme Court has not passed on this argument. See Omni. Capital International v. Rudolph Wolf & Co., Limited, 484 U.S. 97 1988, Mwani v. Bin Laden, 417 F3D 1 DC. Sir. 2005 terrorist group's bombing of United States Embassy in Nairobi, Kenya, provided a basis for United States jurisdiction because it was targeted at the United States. C. Statutory authorization for jurisdiction. 1. Introduction 118. For a court to assert jurisdiction over an out-of-state defendant, there must be a statute or rule that gives the court the authority to exercise jurisdiction. In state court, such authority is usually in the form of a long-arm statute, which operates as enabling legislation. Thus, the first step in a jurisdictional analysis, i.e., before any analysis of minimum contacts or other jurisdictional basis, is to examine this legislation and determine whether it covers the case presented. This often involves a problem of statutory interpretation, deciding what the legislators or rule makers meant by the words selected for the statute or rule. 2. Long-arm statutes 119. In the wake of International Shoe, legislatures began to enact statutes extending the reach of their court's jurisdiction, the long arm of the law. A. Full Power Statutes 120. Long-arm statutes in a few states explicitly authorize exercise of jurisdiction whenever it would not violate the Constitution. See, e.g., Cal. Civ. Proc. Code. 41010. In such states, the only question that need be considered is the constitutionality of jurisdiction. Note that some courts have interpreted statutes that do not expressly provide this broad jurisdiction to nevertheless have this effect. See Infra 126. B. Specific Acts 121. Most long-arm statutes designate specific acts as warranting the exercise of jurisdiction. Common examples include the transaction of any business within the state. 2. The commission of a tortious act within the state. 3. Ownership, use, or possession of real property within the state. 4. Contracting to insure any person, property, or risk located in the state at the time of contracting. And 5. The maintenance of a marital domicile in the state in an action for divorce. With such a statute, one must consider whether the defendant's activities fall within the terms of the statute and Roman II. If so, whether the exercise of jurisdiction in this case is constitutional. 1. Common Sense Reading 122. In general, courts say that they will give the words of the rule or statute their ordinary meaning. In some instances, however, they seem to overextend that reading. Thus, in Gray v. American Radiator and Standard Sanitary Corp. Supra 36, the court read the Illinois statute's provision of jurisdiction for the commission of a tortious act within this state to cover the manufacture in Ohio of an allegedly defective valve that was shipped to a manufacturer in Pennsylvania and incorporated into a boiler made there. Compare Feathers v. McLucas, 15 NY 2D 443 1965 language, tortious act within the state, too clear to include tortious act outside the state that causes an injury within the state. 2. Different Legal Theory 123. If the defendant's specific act is within the statute, claims based on the same act, but a different legal theory usually can also be asserted in the action. Mack Trucks, Inc. v. Aero Aluminum Castings Co. 510 F2D 1E29 5th Sir. 1975. Products liability suit based on tortious act, long arm provision can assert both negligence and breach of contract theories. 3. Arising out of requirement 124. Usually, long arm statutes that designate specific acts require that claims arise out of that act. This presents a problem similar to that in determining whether there is a relationship between the claim and the contacts on a minimum contacts analysis supra 40 and whether specific or general jurisdiction is being invoked supra 80. However, in this instance, the analysis made is of the relationship between the contacts and the claim as a matter of state law, rather than as a matter of federal constitutional law. 4. Tortious Act 125. The tortious act requirement is generally held to be satisfied whenever the plaintiff alleges that the defendant's act was tortious. Nelson v. Miller, 11 Ill. 2D 378 1975. If an actual tortious act were required and the defendant won the case on the ground that the act was not tortious, that could mean that there was no jurisdiction. 5. Full power through interpretation 126. Some long-arm statutes specifically extend jurisdiction to the constitutional limit. See Supra 120. In those states that have specific act statutes, some courts have interpreted the statutes to extend jurisdiction to the constitutional limit. See Worldwide Volkswagen Corp. v. Woodson, Supra 45 Oklahoma statute interpreted as conferring jurisdiction to the limits permitted by Constitution. Nelson v. Miller, super same with regard to Illinois statute. A. Rationale. Often the reasoning behind such extensions is that the legislature had no reason to deny residents access to the courts in cases in which jurisdiction would be constitutional. B. Caution. States that have taken this approach sometimes balk at pursuing it as far as possible. Thus, after Nelson supra, the Illinois Supreme Court cautioned that a statute worded in the way ours should have a fixed meaning without regard to changing concepts of due process. Green v. Advance Ross Electronics Corp. 427 NE2D 1E203 IL. 1981, but note, Illinois later amended its long-arm statute to extend to the constitutional limit. See IL. Code Civ. P. 209C. 3. Federal Court Jurisdiction 127. In general, federal courts exercise jurisdiction no broader than that authorized by state long-arm statutes. A. In personam jurisdiction. Subject to jurisdiction of State Court 128. Process from a federal court will confer jurisdiction over a defendant if the defendant would be subject to jurisdiction of a court of general jurisdiction in the state in which the federal court is located. Fed. R. P. 4K1A. In other words, if the defendant could be served in a suit in the state where the federal court is located, the defendant can also be served in a federal court suit. A. Constitutionality. Where this is the ground for exercise of personal jurisdiction, the constitutionality of that exercise is the same as if the case were in state court. Rule 14 or Rule 19 Joinder 129. Even if local law does not permit service, a party who is served within a judicial district and within 100 miles of the place from which the summons was issued is subject to jurisdiction if joined under Rule 14 Impleter, see Infra 113 et sec. Or Rule 19 Necessary Parties, see Infra 1084 et sec. Fed. R. Civ. P. 4K1B. This is commonly known as bulge jurisdiction. Interpleader or other federal statutory basis 130. Sometimes a federal statute authorizes nationwide jurisdiction. If so, federal courts can exercise jurisdiction even though state courts could not. Examples include Interpleader 28 U.S.C. 361 and Securities Fraud Actions 15 U.S.C. 78A. Fed. R. Civ. P. 4K1C. Service in actions within the federal court's multiparty, multiforum jurisdiction C, e.g., 28 U.S.C. Section 1E369. Civil cases involving at least 75 individuals' deaths from a single accident at a discrete location may be made at any place within the United States or anywhere outside the country if otherwise authorized by law. 28 U.S.C. 11697. 4. Minimum contacts with United States 131. For claims arising under federal law, federal courts can exercise jurisdiction even though the defendant is not subject to the jurisdiction of the courts of general jurisdiction in any state, if this would be consistent with the Constitution. Fed. R. Civ. P. 4K2. This situation usually involves a foreign defendant. A. National vs. State Contacts 132. This provision could apply if the defendant's national contacts permit exercise of jurisdiction, although no state has sufficient contacts to support it. See, e.g., Go Video, Inc. v. Akai Electric Co. 885 F2D 1E406 9th Sir. 1989. B. Narrow Long Arm Statute 133. Alternatively, this provision could apply if the state in which the court is located has a narrow long-arm statute that does not apply to the circumstances presented in the case, although there are constitutionally sufficient grounds for exercise of jurisdiction. Showing defendant not subject to jurisdiction in any District 134. A plaintiff who invokes this ground of jurisdiction must certify that, based on available information, the defendant cannot be sued in any district. To avoid jurisdiction on this basis, The burden is then on the defendant to show that it is subject to suit in some district. See United States v. Swiss American Bank, 191 F3D 31st Sir, 1999. B. In rem jurisdiction 135. The federal court may assert jurisdiction by seizing a defendant's assets found within the district only if defendant cannot be served by an otherwise authorized means, and then only in the manner provided by the law of the state in which the district court is located. Fed. R. Civ. P. 4N2. But note, it may still be possible to challenge the seizure under Schaffer v. Heitner. See Supra 64 et sec. C. No Court Created Authority 136. In Omni Capital International v. Rudolph Wolf & Co., Limited. Supra 117. The court rejected arguments that it should authorize nationwide service of summons in connection with a federal claim for which Congress had not provided for such service. The court found it likely that Congress has been acting on the assumption that federal courts cannot add to the scope of service of summons Congress has authorized. The addition of Rule 4K to Supra 131 provided the authority the court had found lacking. D. Litigating jurisdiction. 1. Introduction 137. Implicit in the idea of consent Supra 93-109 is the need for the defendant to raise personal jurisdiction objections in a timely fashion. In reality, the defendant faces a variety of options. 2. Default 138. A party served with summons who believes that the court lacks personal jurisdiction or authority to serve process on her may disregard the process and allow her default to be taken. If an effort is later made to enforce the resulting default judgment, she can argue that full faith and credit should not be given to the judgment because it was entered by a court without jurisdiction. However, if this argument is rejected, the defendant may not then defend on the merits. 3. Appearance to litigate jurisdiction 139. The defendant can appear in the action and litigate jurisdiction in the court in which the suit was filed. In federal court and in most state courts, the jurisdictional objection can be raised along with other defenses see Supra 104, but in a few states, the defendant would have to enter a special appearance see Supra 103, which raises only the jurisdictional issue. 4. Discovery 140. Where factual issues e.g., defendant's level of contacts with the forum are pertinent to resolution of a personal jurisdiction objection, the court may order discovery regarding those issues. By making a personal jurisdiction objection, the defendant consents to the court's jurisdiction with respect to such discovery. Insurance Corp. of Ireland, Limited, v. Compagnie des Bauxites de Guinée, Supra 106. 5. Binding effect 141. Once the defendant has appeared and litigated jurisdiction, she may not re-raise the issue collaterally to resist full faith and credit. She is estopped from re-litigating the issue. Baldwin v. Iowa State Traveling Men's Association, 283 U.S., 522 1931. A. Appellate Review 142. A defendant whose jurisdictional objections are rejected can appeal that decision in the court system in which the decision was made. However, in the federal courts and many state systems, appellate review is available only after a final decision is rendered, usually only after a trial. See Infra 2070 et sec. In some state systems, earlier review is possible. See Cal. Civ. Proc. Code 41810C. Defendant whose motion to quash service is denied must petition for writ of mandate within 10 days or enter general appearance and waive jurisdictional objection. Venue. 1. Introduction 143. Venue is a statutory limitation on where a suit may be brought. It may prevent a plaintiff from bringing suit in a particular court even though the court has jurisdiction. The venue rules are designed to prevent the plaintiff from suing where it would be burdensome for the defendant to appear and defend. Venue usually is considered after it is determined that there is statutory authorization for the exercise of jurisdiction and that the exercise of jurisdiction is constitutional. A. Federal System 144. Venue statutes in the federal system limit the federal districts in which suit may be brought. B. State Courts 145. Venue statutes in state court systems usually limit the counties in which suit may be brought. 2. Federal Venue Limitations 146. Most suits in federal courts are considered transitory actions, i.e., they may be brought wherever the defendant can be served. Transitory actions are subject to the following venue rules. Cases involving land may be considered local actions, i.e., they may be brought only where the land that is the subject of the suit is located. Local actions are subject to special venue rules, see Infra 175. Generally, for most federal question and diversity cases, venue is proper as follows. Defendant's residence 147. Venue is proper in a judicial district where any defendant resides, if all defendants reside in the same state, whether federal subject matter jurisdiction is based on diversity of citizenship or a federal question. 28 U.S.C. 1391A1, B1. Residence of natural person 148. Ordinarily, residence of a natural person refers to domicile the place she resides with intent to remain indefinitely. In this sense, it is analogous to citizenship for purposes of jurisdiction. See Supra 82. But some cases have interpreted residence to refer also to a district in which a person has a second home. Arley v. United Pacific Insurance Co., 379 F2D 183 9th Sir, 1967. Residence of Corporation 149. A corporation is deemed a resident of any judicial district in which it is subject to personal jurisdiction at the time the action is commenced. 28 U.S.C. 1391C. 3. Unincorporated associations 150. Large unincorporated associations, e.g., labor unions, normally have the capacity to sue or be sued as an entity. Venue is proper in districts in which they are doing business. Denver and Rio Grande Western Railroad v. Brotherhood of Railroad Trainmen, 387 U.S. 556 1967. Partnerships 151. It has been held that partnerships should be treated like unincorporated associations. Prewitt Enterprises, Inc. v. Organization of Petroleum Exporting Countries, 353 F3D 916 11th Sir. 23. Cert. Denied, 543 U.S. 814 2004, although some older cases have used the residence of the partners to determine venue. B. Location of substantial part of events or omissions or of property 152. Venue is proper in a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of property that is the subject of the action is situated, whether federal subject matter jurisdiction is based on diversity of citizenship or a federal question. 28 U.S.C. 1391A2, B2. These provisions are intended to cope with the problem of venue gaps, which could arise when there are multiple defendants, and there is no state that is the residence of all of them. Distinguish where claim arose 153. Until 1990, venue was proper where the claim arose. This term had generated substantial litigation to determine which of several districts was the single one where the claim arose in cases involving multiforum transactions, and the term received a narrow interpretation by the Supreme Court. Leroy v. Great Western United Corp., 443 U.S. 173 1979. Unlike this narrow interpretation, the amended venue statute contemplates that in a number of cases venue may be proper on this ground in more than one district. Application 154. Problem areas in the application of the new statutory provision include the following. A. Giving rise 155. It is not clear whether Congress intended that the pertinent events be only those on which liability is predicated under the relevant substantive law. For example, in a product's liability action against a manufacturer, it is likely that the retail sale of the product would not be an element of the claim C infra. 687. Regarding privity, but the place of retail sale may nevertheless be a proper venue, even if the injury occurred in another district. Substantial Part 156. Although the amended statute contemplates that more than one district may qualify, it is not clear how many events or omissions suffice as a substantial part. Example: where a creditor's demand letter was forwarded to a district by the postal service from plaintiff's old address, receipt of the letter in. The district was held to satisfy the venue requirements for an action under the Fair Debt Collection Practices Act 15 U.S.C. 11692 et seq. The harm Congress sought to protect against occurred when the letter was received. Bates v. C&S Adjusters, Inc., 980 F2D 865 2D Sir, 1992. Example: a government enforcement action against a defendant that had mailed 15 million postcards nationwide could be brought in Iowa, where 200,000 postcards were directed. United States v. Hartbrot, 773. Sup. 1N 240 ST, Iowa 1991. 1. Property present 157. The problem of location of property is similar to the question of location of property for purposes of personal jurisdiction see supra 6264, but turns in this instance on the intent of Congress, which may be to have the federal courts develop federal rules regarding the location of property for venue purposes. A. Property subject of the action. The property must be the subject of the action for this venue provision to apply. B. Distinguish local actions. In some actions, the local action rules see infra 175-178 may apply instead of the provisions of Section 18391. C. Fallback venue used when other venue requirements cannot be satisfied in any District 158. In multi-defendant cases, if there is no other district in which the action may otherwise be brought, there are fallback provisions for venue. 28 U.S.C. 18391A3, B3. The fallback provisions apply only if the other two venue rules supra 147, 152 do not apply, and they differ depending on whether the case is based solely on diversity jurisdiction. 1. Diversity cases venue proper where defendant is subject to personal jurisdiction 159. In diversity of citizenship cases, venue is proper in any district in which a defendant is subject to personal jurisdiction at the time the action is commenced. 28 U.S.C. 18391A3. A. Service within jurisdiction, not sufficient 160. Personal service within the jurisdiction would not suffice to establish venue under Section 18391A3 because it would not be a ground for personal jurisdiction that exists at the time the action is commenced. Federal civil actions are commenced by filing a complaint with the court Fed. R. Civ. P. 3. And the summons issues only upon the filing of the complaint. Fed. R. Civ. P. 4b. Thus, service of the summons does not establish that the defendant was subject to personal jurisdiction at the time the action was commenced. 2. Federal question cases venue proper where a defendant is found 161. In cases in which federal subject matter jurisdiction is not based solely on diversity of citizenship, venue is proper in a district in which a defendant can be found. 28 U.S.C. 18391B3. It appears that found means a district in which she can be served with process. 3. Application as a fallback only 162. A plaintiff who wishes to rely on the fallback provisions must demonstrate that venue cannot be established in any other district. A. Defendant's residence 163. The fallback provision may not be used if all defendants are residents of a single state, since Sections 18391A1 and B1 would apply. In single defendant cases, This means that venue is not proper in a district in which personal jurisdiction can be obtained if the defendant is a resident of another state. B. Substantial portion of acts giving rise to the claim 164. The fallback provision cannot apply if there is any district in which a substantial portion of the acts or omissions giving rise to the liability occurred, because that would suffice for venue under Section 1E391A2 or B2. Thus, the fallback provision can only apply if no substantial portion of the acts or omissions giving rise to liability happened in this country. D. Special Venue Statutes 165. Congress has altered the general rules of venue in connection with certain types of cases. 1. Additional Venue Options 166. In some types of cases, venue may be proper in certain locations in addition to the districts allowed under the general rules. Patent Infringement Actions 167. In addition to the districts specified by the general venue statutes, venue in a patent infringement action is also proper in the district where the defendant committed acts of infringement if the defendant has a regular and established place of business in that district. 28 U.S.C. 14400B. B. Copyright Suits 168. Similarly, in addition to the districts specified by the general venue statutes, venue in copyright suits is proper in any district in which the defendant or her agent may be found. 28 U.S.C. 14400A. 2. Substitute Venue 169. In a few types of cases, venue is proper only in the districts specified by the special statute. A. Federal Tort Claims Actions 170. Venue for federal tort claims actions is proper only in the district where the plaintiff resides or where the act complained of occurred. 28 U.S.C. 14402B. B. Statutory Interpleader 171. In statutory interpleader actions, venue is proper only in a district where a claimant to the fund resides. 28 U.S.C. 14397. E. Aliens 172. In a suit against an alien, venue is proper in any district. 28 U.S.C. 14391D. 1. Distinguish citizenship for determination of diversity of citizenship 173. Where the residence of an alien must be considered to determine whether there is subject matter jurisdiction due to complete diversity of citizenship. An alien admitted to the United States for permanent residence is deemed a citizen of the state in which the alien is domiciled. See Infra 302. F. Removed Cases 174. Where a case is removed from state court to federal court, it is assigned to the district encompassing the state court in which the action was pending, regardless of the residence of the parties. 28 U.S.C. 14441A. In a sense, removal creates its own venue. G. Local Actions 175. Certain types of cases involving title to property are considered local, and venue is regarded as proper only in the district where the property is located. In effect, this is an unwritten limitation on the federal venue statutes, treating them as applicable to transitory actions only. Example, in Livingston v. Jefferson, 15 Fed. Cass. 660D. Va. 1D811, plaintiff charged former President Jefferson with trespass to plaintiff's land in Louisiana. The court refused to proceed with the case because it was a local action that could be brought only in Louisiana where personal jurisdiction could not be obtained over Jefferson. 1. In Rem Analogy 176. One court has explained that the difference between local and transitory actions is the same as that between in personam and in rem jurisdiction, and that an action is a local action only if the court needs to have jurisdiction over the real property in order to grant relief. Raphael J. Musicus, Inc. v. Safeway Stores, Inc. 743 F2D 503 7th Sir. 1984. 2. Property in Multiple Districts 177. Where the property is located in more than one district in the same state, the action may be brought in any of those districts. 28 U.S.C. 183-92b. 3. Treated as a matter of subject matter jurisdiction 178. Some courts treat the local action rule as a limitation on subject matter jurisdiction. See Infra 388. 3. State venue limitations 179. State venue provisions involve similar considerations to federal venue rules. A. Defendant's residence 180. Traditionally, in personam actions can be brought in the county where the defendant resides, and where multiple defendants are sued, the action may be proper in any county where one of them resides. See Cal. Civ. Proc. Code 395. B. Where claim arose 181. In some jurisdictions, most or some types of claims, e.g., tort claims, can be brought where the claim arose. See Cal. Civ. Proc. Code 395A. An action for personal injury. Venue is proper in county where injury occurs. C. Actions affecting real property 182. Where the action affects title to real property, venue is usually in the county where the property is located. See Cal. Civ. Proc. Code 392A1. D. Non-resident defendant 183. In general, non-residents are regarded as having no venue rights, and the plaintiff may often sue them in any county. See Cal. Civ. Proc. Code 395A. 1. Equal protection challenge rejected 184. A state may allow an out-of-state corporation to be sued in any county without violating the Equal Protection Clause, even when it limits suits against an in-state corporation to the county of its principal place of business. It is rational to weigh differently the inconvenience of a domestic corporation in defending a suit in a forum distant from its principal place of business and II the burden on an out-of-state corporation that must defend away from home in any event. Burlington Northern Railroad v. Ford, 504 U.S. 648, 1992. 4. Litigating venue 185. As with personal jurisdiction, improper venue may be waived unless raised in the proper way. In federal court, for example, it is waived unless it is raised in the first Rule 12 motion or in the answer if there is no Rule 12 motion. See Fed. R. Civ. P. 12H1. A. Effect of timely venue objection. Where the defendant timely objects to venue, the court cannot proceed with the case. It may dismiss, but in most jurisdictions it can also transfer the case to a court that is a proper venue. See Infra. 5. Federal Transfer Provisions 186. A federal case may be transferred to another federal court in the following circumstances. A. Venue or jurisdiction improper in original court 187. Where venue or jurisdiction is improper in the court selected by the plaintiff and the defendant properly objects, the court may transfer the case to a proper court rather than dismiss it. 28 U.S.C. 18406A. 1. Transfer where jurisdiction also improper 188. Although the statute only talks of transfer where venue is improper, the Supreme Court has held that it authorizes transfer where both jurisdiction and venue are improper. Goldlauer, Inc. v. Hyman, 369 U.S. 463, 1962. 2. Transfer where venue proper but jurisdiction lacking 189. Lower courts have upheld transfer from a district where venue is proper, but there is no personal jurisdiction. Bentz v. Resile, 778 F2D 1E26 5th Sir, 1985. 3. Court may dismiss, not transfer 190. Although the district court may choose to relieve the plaintiff of some adverse consequences of filing suit in a district in which venue or jurisdiction is improper by transferring to a proper venue, it may dismiss instead of transferring. See Nichols v. GD. Cyril & Co. Supra. 88 District Court acted within its discretion when it dismissed rather than transferred where plaintiff's attorney committed obvious error in filing suit in the wrong court, and thereby imposed substantial unnecessary costs on defendant and the legal system. B. Transfer for convenience 191. Where venue and jurisdiction are proper in the court selected by the plaintiff, the court can transfer the action for the convenience of the parties and witnesses in the interests of justice. 28 U.S.C. 11404A. 1. Distinguish forum non-conveniens 192. This transfer provision considers many factors that bear on the question of whether to dismiss on forum non-conveniens grounds see infra 212, but it permits transfer on a lesser showing of inconvenience. Norwood v. Kirkpatrick, 349 U.S. 29 1955. As the Supreme Court has explained, for the federal court system, Congress has codified the doctrine and has provided for transfer, rather than dismissal, when a sister federal court is the more convenient place for trial of the action. Sinocom International Co. v. Malaysia International Shipping Corp. 127 S. CT. WINN 184 2007. 2. Proper Transferee Court 193. The statute authorizes transfer only to a district in which the action might have been brought. This means that the transferee district must be a proper venue and have valid personal jurisdiction. The moving party's willingness to waive objections to venue or personal jurisdiction does not satisfy this requirement. Hoffman v. Blasky, 363 U.S. 335 1960. 3. Procedure. A. Proper moving parties 194. Either the plaintiff or the defendant can move to transfer under this section. Ferens v. John Deere Co. 494 U.S. 516 1990. Plaintiffs moved to transfer, arguing that they had sued in an inconvenient district. A defendant who has removed a case from a state court can still move to transfer after removal. Lynch v. Vanderhoof Builders, 237 F. Sup. 2D 615D. MD. 22. B. Showing required 195. In general, the plaintiff's initial choice of forum should be respected, and that transfer is proper only when the balance of conveniences strongly favors transfer. This showing should look to the identity and location of witnesses, access to items of real evidence, and any other factor that would make trial in the transferee forum more convenient. 4. Forum Selection Clause 196. Where the parties have entered into a contract containing a forum selection clause concerning the dispute in question, the Supreme Court has stated that the presence of the clause should be a significant factor in determining whether to transfer the case to the forum designated. Stewart Organization, Inc. v. Rico Corp. 487 U.S. 22 1988. C. Multidistrict Litigation 197. When cases pending in different districts raise a common question of law or fact, they can be transferred to one district. 28 U.S.C. 14407. 1. Showing required 198. All that need be shown is that the actions share a common question of fact or law. Unlike transfers for convenience under Section 1E 404A Supra 195, there is no preference for plaintiff's choice of forum. 2. For pretrial purposes only 199. This transfer is for pretrial purposes only. The cases should be remanded to the original court for trial. 28 U.S.C. 14407A. The transferee court has full power to pass on any pretrial matters. However, 3. Follow-up transfer for trial not authorized 200. Despite widespread support for the practice among lower courts, the Supreme Court has held that Section 14407A does not authorize the judge who receives a multidistrict transfer to use Section 1E404A to transfer cases to her court for trial. Lexicon, Inc. v. Milberg, Weiss, Bershad, Hines, and Larach, 523 U.S. 26 1998. 4. Procedure 201. Motions for transfer are directed to the Judicial Panel on Multidistrict Litigation, which holds hearings and has the authority to transfer to any district, without reference to venue or jurisdiction. D. Effect on choice of law 202. In cases in federal court on grounds of diversity of citizenship, the transfer could affect choice of law because in such cases the federal court is required to look to the choice of law rules of the state in which it sits to determine choice of law issues. Claxon Co. v. Stentor Electric Manufacturing Co. 313 U.S. 487 1941. 1. Venue and jurisdiction proper in original court 203. In cases where the plaintiff sues in a court that has proper venue and jurisdiction, a transfer for the convenience of the parties does not affect choice of law because the transferee court is to apply the same choice of law rules that the transfer court would have applied. Van Dusen v. Barrick, 376 U.S. 612 1964. The Van Dusen rule applies even when the transfer is on motion of the plaintiff who chose the inconvenient forum in the first place and thus could shop for more favorable law. Ferens v. John Deere Co. Supra, 194. 2. Venue or jurisdiction improper in original court 204. If the plaintiff could not have overcome the defendant's venue or jurisdiction objections in the original court, the choice of law rules of the transferee state should usually be applied. Wisland v. Admiral Beverage Corp. 119 F3D 733 8th Sir. 1997. 3. Federal Claims 205. Because the federal circuits sometimes disagree on issues of federal law, it is possible for similar choice of law problems to arise where a claim is transferred from one circuit to another. Ordinarily, the interpretation of the transferee circuit is applied in this circumstance. In Re TMJ Implants Products Liability Litigation, 97 F3D 1058 Sir. 1996. In Re Korean Airlines Disaster of Sept. 1, 1983, 829 F2D 171 DC. Sir. 1987. F. D. On other grounds, sub nom. Chan v. Korean Airlines, 490 U.S., 122 1989. 6. Transfer in State Court 206. State courts often have transfer provisions analogous to the federal provisions. See, e.g., Cal. Civ. Proc. Code 396 transfer where jurisdiction lacking. 397C transfer for convenience of witnesses. Cal. Rules of Court 3501 et sec. Coordination of actions involving common questions of fact or law. F. Forum non-convenience. 1. Background 207. Even when jurisdiction and venue are proper, courts may decline to exercise jurisdiction on the ground that the location the plaintiff selected for the case is grossly inconvenient. This ancient common law doctrine was endorsed by the Supreme Court as a matter of federal common law in Gulf Oil Corp. v. Gilbert, 330 U.S., 501 1947, and is recognized in almost all state courts. 2. Present use. A. Federal Courts 208. When the inconvenience problem can be solved by transfer to another federal district, the court may not dismiss, but if the proper forum is in another country, the federal court can dismiss. Piper Aircraft Co. v. Reno, 454 U.S., 235 1981. In Reunion Carbide Corp. Gas plant disaster at Bhopal, India, 809 F2D 195 2D Sir, Cert. Denied, 484 U.S., 871 1987. B. State Courts 209. When the more convenient court is not within the state and transfer is therefore not possible, see Supra 206. Regarding in-state transfer forum non-convenience remains an important device. 3. Rationale. Courts are not required to make their jurisdiction available to parties who engage in unfair forum shopping and thereby impose substantial inconvenience on other parties and expense and burden on the courts of the forum selected by the plaintiff. 4. Procedure 210. The defendant must make a motion to dismiss on grounds of inconvenience. A. Showing required 211. The defendant must show that the plaintiff has selected a grossly inconvenient. Location for the suit. 1. Distinguish transfer. In federal court, the showing necessary to justify transfer is not as compelling as the showing needed to justify dismissal on forum non-convenience grounds. B. Factors 212. The court is to consider a number of private and public factors in making a decision whether to dismiss on forum non-convenience grounds. See chart infra. C. Weight given plaintiff's choice 213. Usually, substantial weight is given to the plaintiff's choice to sue in a forum where venue and jurisdiction requirements are satisfied. When the plaintiff is foreign, however, that deference is not warranted. Piper Aircraft Co. v. Reno, Supra, 208. D. Change in Substantive Law 214. The fact that the law in the more convenient forum is less favorable to plaintiffs usually has no significant weight. Piper Aircraft Co. v. Reno, Supra. E. Adequate alternative forum available 215. The court cannot dismiss unless an adequate alternative forum is available to the plaintiff. 1. Adequate remedy 216. The alternative forum must offer an adequate remedy. If there is no possibility of foreign judicial relief, the American court may conclude that the forum is inadequate. But the remedy need not be the same as in an American court, and the procedure of the foreign court may differ from that of the American court. Piper Aircraft Co. v. Reno, Supra dismissal upheld even though alternative forum was Scotland, where plaintiffs would not be able to rely on products liability theories. Compare Phoenix Canada Oil Co. v. Texaco, Inc., 78 FRD, 445D. Dell. 1978 alternative forum in Ecuador might not be willing to hear the case, and there was no generally codified Ecuadorian legal remedy for the unjust enrichment and tort claims asserted. 2. Jurisdiction 217. The alternative forum must have jurisdiction over the defendant, but this problem can be solved by a stipulation by the defendant to submit to jurisdiction there. F. Conditions on dismissal 218. The court can condition the dismissal to protect against unfairness to the plaintiff. A common example is insistence on a stipulation by the defendant that the statute of limitations will be deemed told as of the time suit was filed in the inconvenient forum, so that plaintiff does not risk a limitations defense based on the delay between the filing of the original case and the filing of suit in the preferred forum. 5. Effect on choice of law 219. Because forum non-convenience results in a dismissal, the plaintiff must file a new suit, and the choice of law rules that apply are determined by the forum of the new suit. 6. Contractual limitations on forum 220. Dismissal in favor of litigation in another forum can also occur where the dispute arises out of a contract in which the parties have agreed to litigate in a specific forum, but transfer to that forum is not possible. A. Federal law generally enforceable 221. The Supreme Court has declared that, as a matter of federal common law, such clauses are generally enforceable even where they result in dismissal because the forum chosen is in another country. See the Bremen v. Zapata Offshore Co., 407 U.S. 1972 clause should be enforced absent showing that doing so would be unreasonable and unjust, or that the clause was invalid for such reasons as fraud or overreaching. Moreover, the Supreme Court has held that a forum selection clause on a printed passenger ticket is enforceable, even though not the subject of bargaining, unless enforcing it would violate fundamental fairness. Carnival Cruise Lines, Inc. v. Shoot, 499 U.S. 585 1991 note. Congress invalidated such clauses in Ship Passenger Tickets 46 App. USC 183C, but later re-amended the statute to restore the original language, although apparently intending still to change the result in Carnival Cruise Lines. Such clauses may be valid in other consumer situations, however. B. State Law Enforcement Limited 222. In many states, the enforcement of such clauses is limited, on the theory that the parties cannot by agreement oust a court with jurisdiction to decide the dispute. C. E.g., Stewart Organization, Inc. v. Rico Corp. Supra. 196. Alabama looks unfavorably upon contractual forum selection clauses. C. Choice between state and federal rules in Federal Court 223. Where state law claims are presented in federal court, there may be a serious problem determining whether to apply state or federal common law. The Supreme Court has not decided this question. See Stewart Organization, Inc. v. Rico Corp. Supra. It has, however, decided that where transfer to the selected forum is possible under 28 U.S.C. Section 1E 404A, the existence of such a clause is a significant factor in deciding whether to transfer. G. Notice. 1. Introduction 224. In addition to personal jurisdiction and venue, problems of notice should be considered. Notice is not a substitute for these other factors, but is essential to a valid judgment. 2. Constitutional requirements 225. Due process requires that reasonable efforts to provide notice be made with regard to persons whose interests are to be determined. Mullane v. Central Hanover Bank and Trust Co., Supra. 74. A. In rem cases 226. The notice requirement applies even to pure in rem actions. Walker v. City of Hutchinson, 352 U.S. 112, 1956. B. Method 227. The method of giving notice must have a reasonable prospect of giving actual notice. The means employed must be such as one desirous of actually informing the absentee might reasonably adopt to accomplish it. Mullane v. Central Hanover Bank and Trust Co., Supra. 1. Personal delivery 228. Personal delivery of the notice. Ordinarily, the summons and complaint is the traditional method of giving notice. 2. First-class mail 229. In Mullane, Supra, the court required mailed notice to those whose addresses were known, reasoning that the mails today are recognized as an efficient and inexpensive means of communication. A. Class Actions 230. In class actions brought under Federal Rule 23b3 common question suits, there must be mailed notice to all class members who can be identified with reasonable effort. Eisen v. Carlisle and Jacqueline, 417 U.S. 156, 1974. B. Notice to prisoner 231. Notice of a forfeiture proceeding mailed to a prisoner was constitutionally sufficient because the prison used reasonable means to deliver mail to prisoners. Dusenberry v. United States, 534 U.S. 161, 2010. 3. Posted notice 232. Notice by posting on the defendant's residence may not be sufficient. Green v. Lindsay, 456 U.S. 444 1982 State Procedure for giving notice of eviction proceedings by posting on the front door of apartment invalid in light of testimony that notices were often torn off doors. Notice by mail required. 4. Service via e-mail 233. Under Federal Rule 4F3, a court may authorize service via email when service by more conventional means has been shown to be impossible. Rio Properties, Inc. v. Rio International Interlink, Inc. 284 F3D 1007 9th Sir. 22 defendant had announced to the world that it preferred to receive communication through its email address, and plaintiff's numerous attempts to serve defendant by other means had been thwarted by defendant's manner of doing business. C. Effort to identify 234. Reasonable efforts to identify and locate affected persons are required. As to named defendants, the identification issue should not be a problem, but in other instances, such as in rem actions, it can prove more difficult. Example: mortgagee, where property was sold for non-payment of taxes. The mortgagee with a mortgage on file with the county recorder was held entitled to notice of the sale. Mennonite Board of Missions v. Adams, 462 U.S. 791 1983. Example: creditor of decedent. Application of a state requirement that claims against a decedent be presented to his executor within 2 months of publication of notice of the commencement of probate proceedings was held to violate due process where it cut off rights of creditors whose identity was reasonably ascertainable to a decedent's executor and who were not given notice. Tulsa Professional Collection Services, Inc. v. Pope, 485 U.S. 478, 1988. 1. Class Actions 235. In class actions, the court has accepted failure to identify significant numbers of class members. See Eisen v. Carlisle and Jacqueline, supra inability to locate more than half of 6 million class members rationale. In Mullen v. Central Hanover Bank and Trust Co. Supra, the court explained that notice reasonably certain to reach most of those interested in objecting is likely to safeguard the interests of all, since any objection sustained would inure to the benefit of all. A. Distinguish future claims class action. In a class action involving future claims by class members who had not yet manifested illness due to exposure to asbestos, the Supreme Court cautioned that providing adequate notice to such individuals might be impossible due to problems of identification and to the uncertainty caused for those who may not even know of the asbestos exposure at the time of any notice that is given. Amcom Products, Inc. v. Windsor, 521 U.S. 591, 1997. D. Contents 236. The notice must intelligibly advise the defendant of the nature and place of the proceeding. E. Constructive Notice 237. In some instances where a person cannot be located after reasonable efforts, published or other constructive notice will suffice. See e.g. Cal. Civ. Proc. Code. 41550 Service by publication where party cannot by reasonable diligence be served another way. F. Effective failure to receive 238. If a constitutionally valid procedure is used, the judgment is binding even if some interested parties do not actually receive notice. Due process requires reasonable efforts to provide notice, but Supreme Court cases have never required actual notice. Dusenberry v. United States, Supra 231. G. Duty to make further efforts if notice not received 239. When the state learns that its initial efforts at giving notice failed, even though they were reasonable, it must take reasonable additional steps to provide notice. Jones v. Flowers, 547 U.S. 220-26 when certified letter notifying homeowner that house would be sold to pay overdue taxes was returned. Due process required the state to take reasonable additional actions to notify the owner before selling the house. 3. Service of Process 240. The usual method for giving notice is service of a summons and complaint on the defendant directing that the defendant file an answer to the complaint or suffer a default. A. Jurisdiction distinguished 241. Although service of process implies an exercise of jurisdiction, the questions of jurisdiction and method of service should be kept separate. Even where the method of service is proper, the defendant can still challenge the exercise of personal jurisdiction, although some forms of service may by themselves suffice to establish personal jurisdiction. Burnham v. Superior Court, Supra, 11 Personal service in state sufficient to establish jurisdiction. B. Methods of service 242. Service of process can be accomplished by the following methods. 1. Personal delivery 243. Process may be served on the person. In the case of a corporation, partnership, or unincorporated association, service may be made on an officer or managing agent, or on an agent authorized by law. 2. Substituted service 244. Other means of service may be authorized by statute or court rule. A. Federal Rules. 1. At defendant's home 245. A copy of the summons and complaint can be left at the usual place of abode of the person to be served with a person of suitable age and discretion residing therein. Fed. R. Civ. P. 4E2B. 2. in accordance with State Law 246. Service also may be made pursuant to the law of the state in which the district court is located or pursuant to the law of the state in which service is effected. Fed. R. Civ. P. 4E1. 3. Waiver of Service 247. A plaintiff may ask a defendant to waive formal service. This is done by sending a request for waiver of service to the defendant by first-class mail. Because a defendant has a duty to avoid unnecessary costs of service, a defendant located within the United States who fails to waive service without good cause can be liable for the costs of formal service. A defendant who waives service receives additional time to answer the complaint compared to one who is served in the usual manner. Fed. R. Civ. P. 4D. 4. On defendant in foreign country 248. A defendant served in another country may be served by an internationally agreed means or, if there is not an agreed means, as directed by the law of the place of service, including, unless forbidden by the law of that country, personal delivery or any form of mail requiring a signed receipt, or as directed by the court. Fed. R. Civ. P. 4F. B. State Law 249. State law on substituted service varies. For example, in California such service may be accomplished in the following ways. 1. At defendant's office or home 250. A copy of the summons and complaint can be left at the person's office or abode plus mailing a copy to that place. Cal. Civ. Proc. Code 41520. 2. By mail within State 251. A copy of the summons and complaint can also be mailed to a person within the state if the person executes and returns an acknowledgement of service. Cal. Civ. Proc. Code 41530. 3. By mail outside State 252. A copy of the summons and complaint can be served on a person outside the state by using return receipt mail, without the need for execution of an acknowledgement by the defendant. Cal. Civ. Proc. Code 41540. 3. Service in diversity cases 253. In diversity cases, the service procedures of Federal Rule 4 are to be applied supra 245-248. Hanavi. Plumer, 380 U.S. 460 1965. C. Immunity from Service 254. In some jurisdictions, there are rules that forbid service of process on a person who is in the state only to participate in a legal proceeding. Rationale: this immunity is designed to protect against the risk of people being unwilling to attend trials for fear of being served with process. These rules have been severely limited in recent times. 4. Timing of notice prejudgment seizures. A. Introduction 255. At common law, a plaintiff could have a defendant's property seized as a method of coercing the defendant to appear for trial. Over time, this seizure, variously called replevin, attachment, garnishment, sequestration, came to be used to provide security for any judgment the plaintiff might obtain in the action. Very often, such prejudgment remedies were available before defendant was given notice of the action. B. State Law Requirements 256. Partly in response to constitutional decisions see Infra 258 et sec, states placed limits on such prejudgment remedies. Thus, before considering possible constitutional objections to state procedures, first consider whether the prejudgment seizure sought by the plaintiff is authorized by state law. Example: California. In California, attachment is available only in contract actions for more than $500 for a fixed or readily ascertainable amount. In an action against a natural person, attachment is available only if the claim arises out of the defendant's conduct of a trade, business, or profession. Cal. Civ. Proc. Code 483-010. Example: New York. Prejudgment attachment is allowed in New York only where there is a showing that the defendant has, or is about to, assign, dispose of, or secrete property, or that the defendant is a non-domiciliary, or a resident who cannot be served in the state. New York Civ. Prac. Law 6 and 201. 1. Federal Courts 257. Federal courts must apply state law concerning the availability of prejudgment remedies unless a federal statute provides a prejudgment remedy. Fed. R. Civ. P. 64. C. Procedural due process requirements for prejudgment seizure 258. In a series of cases, the Supreme Court has considered the constitutional requirements for procedures attending issuance of prejudgment remedies. Because these cases are difficult to reconcile, it is worthwhile to consider them one by one. 1. Snyadach Garnishment of Wages 259. In Snyadach v. Family Finance Corp. 395 U.S. 337 1969, the court held that the state violated a defendant's due process rights by allowing prejudgment garnishment of wages. The opinion contained suggestions that wages might be viewed as a special type of property because they are essential to everyday life. 2. Fuentes seizure of chattels 260. In Fuentes v. Chevin, 407 U.S. 67 1972, the court invalidated Florida and Pennsylvania procedures for writs of replevin that authorized the seizure of property because there was no provision for notice and a procedure hearing. A. Purpose of Hearing 261. The court emphasized that the notice and hearing requirement ensured a fair process of decision-making, but it was not clear on whether this was limited to reducing the risk of erroneous issuance of writs of replevin. B. Alternative Safeguards Against Error 262. The plurality viewed alternative safeguards against error as significant factors in determining the type of hearing afforded, but the safeguards were far from enough by themselves to obviate the right to a prior hearing of some kind. One dissenter argued that the bond requirement, coupled with the creditor's desire to have the transaction completed, should provide sufficient protection. C. Unimportance of cost of hearing 263. The court placed little importance on the possible cost of more elaborate hearing procedures, noting that the Constitution recognizes higher values than speed and efficiency. D. Exception for extraordinary situations 264. The plurality recognized in dictum that the right to procedure notice and hearing could be overcome in extraordinary situations. It specified 3 factors that appeared to be necessary. 1. Such seizures should be directly necessary to secure an important governmental or general public interest, e.g., public health or the war effort. 2. Such seizures without notice may occur only where delay would be inimical to the public interest. And 3. Such seizures should be limited to circumstances in which the state controlled the initiation of proceedings. 3. Mitchell 265. In Mitchell v. W.T. Grant Co., 416 U.S., 61974, the court upheld Louisiana's procedure allowing the seller of several household appliances to obtain a writ for their seizure when the defendant missed payments. A. Fuentes overruled. 266. One could argue that Mitchell overruled Fuentes since the situation was difficult to fit within the extraordinary situations analysis of Fuentes. In dissent, the author of the Fuentes opinion asserted that the case had been overruled. B. Mitchell's requirements Fuentes distinguished 267. However, the majority in Mitchell said that it was applying Fuentes, and that the Louisiana procedures were different in ways that made them constitutional because 1. They required more than the conclusory claims of ownership called by the state procedures at issue in Fuentes. 2. Where this case arose, the practice was that a judge rather than a clerk would pass on the application for the writ. 3. Narrowly confined issues were presented by the application for the writ in Louisiana in contrast to the broad fault standard applicable in the statutes at issue in Fuentes. And 4. The defendant in Louisiana had a right to an immediate hearing on whether the plaintiff was entitled to the writ, and the burden remained on the plaintiff to justify the issuance of the writ. See explanation for Shift 268. The easiest explanation for the shift from Fuentes to Mitchell is that 2 new Justices Powell and Rehnquist were added to the court in the interim. 4. Dechem 269. In North Georgia Finishing, Inc. v. Dechem, Inc., 419 U.S., 601 1975, the court struck down Georgia garnishment procedures. Its description of the distinguishing factors that made the case different from Mitchell provide a guide to important constitutional criteria. A property not subject of Suit 270. Unlike Fuentes and Mitchell, the property in Dechem, a bank account, had no intrinsic relation to the claim. B. Purpose of Due Process Requirements 271. The majority opinion found that the procedure in Fuentes was unconstitutional because the seizures there were carried out without notice and without opportunity for a hearing or other safeguard against mistaken repossession. This seemed to revise the thrust of the Fuentes opinion, which treated the presence of safeguards as bearing on the type of hearing required, not the need for procedure notice at all. 5. Doher 272. In Connecticut v. Doher, 501 U.S., 1991, the court struck down Connecticut's provision for attachment of real property without prior notice and an opportunity for a hearing as applied in this case. The court followed a 3-step analysis based on Matthews v. Eldridge, 424 U.S., 1976. A private interest 273. The court held that the interests of a homeowner were significantly affected by attachment even though it did not interfere with possession of the property because attachment can cloud title, impede sale, and interfere with borrowing on the property. B. Risk of erroneous deprivation 274. The court found that there was a substantial risk of an erroneous deprivation because the state practice allowed decisions based on a conclusory affidavit without prior notice and adversary hearing, and the underlying issue in the case, an alleged assault, did not lend itself to documentary proof. C. Governmental Interest 275. Connecticut had no significant interest in allowing a private plaintiff to attach defendant's property without notice or a showing of exigent circumstances, in view of the fact that other states have more exacting requirements for seizure without notice. 6. Post-Doher decisions. A. Application to Drug Forfeiture Seizure 276. In United States v. James Daniel Good Real Property, 510 U.S., 43 1993, the court held that seizure of defendant's home after his conviction for drug trafficking there violated due process because he did not receive procedure notice and an opportunity to be heard. The seizure deprived him of use of the property, created an unacceptable risk of error because owners are entitled to an affirmative defense of innocent ownership, and was unnecessary to protect the government's interest because real property cannot abscond. B. Cognivant Notes 277. Related issues arise in connection with cognivant notes, in which the debtor agrees that in the event of a default in payments, the creditor may immediately, and without notice, obtain a judgment against the debtor. The Supreme Court has held that if such arrangements are the result of arm's-length negotiation between sophisticated commercial entities, they are enforceable over procedural due process objections. D.H. Overmeyer Co. v. Frick Co. 405 U.S. 174 1972. C. Delay in Hearing 278. Although unreasonable delay in holding a post-deprivation hearing might violate due process, administrative needs may justify a delay of up to 30 days. See City of Los Angeles v. David, 538 U.S. 715 2330-day delay on hearing regarding the return of money plaintiff had to pay to recover his car after it was towed was reasonable. 7. Effective Doher 279. Doher, supra, appears to have the following effects besides prescribing the 3-part analysis of Matthews, supra. A. Exigent Circumstances 280. The court's opinion suggests that proof of exigent circumstances may be constitutionally necessary to permit seizure without notice. Compare Supra 264 regarding extraordinary situations under Fuentes. B. Effect of pre-existing interest in property 281. The court distinguished its summary affirmance in another case involving a mechanic's lien, suggesting that less rigorous standards might apply when the plaintiff is asserting an interest in the property that antedates the suit. C. Type of Claim 282. The court's emphasis on the difficulty of evaluating the assault claim before it on the basis of filings by plaintiff suggests that only claims that can be reliably evaluated on documentary proof may be the basis for seizure without notice. D. Due process limitations if hearing held before seizure 283. Even if a hearing is held before seizure, procedural due process may limit seizure unless the above criteria are satisfied.